So Maxwell, rest assured, you will have sound very soon if it is not already up. So today we are looking at two issues. So the Supreme Court has spoken about the Chief Justice's fight for her rights. We will get to talk about that. And then Chairman Wontumi is his current detention lawful or unlawful? We'll look at the constitutional provisions, the statutes in our country, and why it has become important that these things don't happen. We'll talk about that. And then there is the issue of a certain fake doctor which has been making the rounds in our country the whole of this week. We're going to talk about it. We want to ask if the government got it wrong or got it right in its quest to appoint this lady. What was the search that was done? What was the background checks that were done before the appointment? Okay, so we'll get to talk about that as well today on the show. My guests who are joining me, Dennis Ofori Esiedu. He is a private legal practitioner and a member of the National Democratic Congress. He's already in the studios, and let me welcome him this morning. Good morning to you, Dennis.
Good morning, Wilberforce.
It's good to see you.
Good to see you too. Happy to be here.
Yeah, is this your first time on the forum?
Yes.
This is your
on
first
the forum,
time.
This is my first.
But you've been on other programs of Asaase.
Yes, once. I've been on a one-on-one show with some other hosts here in the studio.
So welcome to the forum this morning.
Thank you.
And then we will also be joined by lawyer Alex Gyamfi. Lawyer Alex Gyamfi is a private legal practitioner, and he's joining us today with his thoughts. And then also we would have Oxford Osei Bonsu. He's also a lawyer in private practice. He's also going to join me. So today the show is all about lawyers. Obviously we are talking about people's rights, and so it's only right that we have lawyers coming up to talk about them. All right, so let's start the conversation today via telephone, and that's because Kwame Adofo, he is also a lawyer. He's also joining us on the line this morning as we begin the conversation before we come into the studio. A very good morning to you, Counsel. Good morning to you, Counsel.
Good morning. Can you hear me?
Yes, we can hear you loud and clear. Thank you very much for choosing to speak to us here on Asaase.
Excellent.
All right. So, I'm looking at the two issues we are discussing today, and it would appear to me that it is all about rights. The Chief Justice has been in the Supreme Court fighting for her rights. She says that you said you have established a prima facie case against me. Give me a copy of it so that it becomes the basis for which you investigate me. There is a certain regional chairman of the MPP who has been arrested. He's been in detention well over 48 hours now, and people are asking questions about whether or not the rights in the Constitution still exist as compared to the work that is being done by the investigators. I want you to first of all make a comment about rights when it comes to fundamental human rights. What are the kind of guarantees that we have been provided with as a people in the Constitution that governs our country?
Look, let me greet you again and the panel, and as well as your listeners. Look, rights generally is about, it's got biblical. Do unto others as we want them to do unto you. When we say that there's rights, there are certain rights that are not even written, such as natural justice and procedural fairness rules. They are not written, even in the Constitution. But it's a common law right recognized in law that you cannot make a decision and end up violating the rights of certain individuals. It's what we lawyers use as stripes. It goes without saying. I think that's how I should say it. It goes without saying. Now, there are two matters that arose this week. The first one has to do with the CJ and her treatment so far. I think on reflection, I would say it's a very sad state of affairs that Ghana finds itself in. And I repeat that it is not about CJ Tokono as an individual. It's about the office of the Chief Justice, where she happens to be the head of a branch of government. And it is therefore important that not only must justice be done, it must also be seen to be done. This week began, interestingly, with some supplementary affidavits circulating in the media. And if you read the affidavit, clearly you can see the injustice that is going on as far as this committee is concerned. And where there's an injustice, where do you run to? There's only one forum that you run to, either the lower courts or the superior courts. In this case, the Chief Justice had to go to the Supreme Court. And without letting the Supreme Court know exactly what is going on, there's no way the Supreme Court would have known. I was shocked to hear that in court, the court strike out the supplementary affidavit as being contrary to Article 146 in terms of confidential provisions. I just could not understand what that means. Is the Supreme Court telling us that the committee can do whatever it wishes, even if it is in violation of the law, Audi or Terran Party rule, which is we call natural justice and procedural fairness? Even if it's in violation of that, is that what the Supreme Court is telling us? That they are at liberty to do whatever they want because it's supposed to be held in Canberra. Unbelievable. But that is what the Supreme Court is telling us now. Now, there were other matters that I thought was interesting. The first one was whether the in-camera provision is so entrenched to the extent that it cannot be waived. That was interesting in the sense that, there is a provision in the law. When I say in the law, in the Constitution, where they say when a person is charged with an offense, there is a presumption of innocence until the person is proven guilty. I'm sure this one is, everybody knows this. Generally, we presume you, even when we have seen that you have killed someone, committed murder, we still say you are innocent until the prosecutors will come and prove you guilty. However, in spite of that presumption of innocence, when an accused person goes to court, he can waive that right to innocence and plead guilty. So that should tell us that even though there's a constitutional provision saying you are presumed innocent, that right can be waived by the accused person. Are you following me?
I'm following you so well. So
okay.
Well.
Okay. Even though there's a constitutional provision that says you are innocent until they have proven that you are guilty, you yourself can go to court and say, look, I'm waiving that right. I'm rather pleading guilty. And the court will accept it and allow you to waive your rights. So it is therefore not true or correct for the Supreme Court to say that because it is a provision of the Constitution that should be held in Canberra, it cannot be waived. That position is wrong, even though that is their position. It is the law now. But I am of the view that it's wrong because it's about the protection of the individual. And if the individual himself or herself says, I'm waiving that right, you cannot say it cannot be waived. Because in other situations, even in criminal situations where somebody's life and liberty is at stake, which is the highest form of protection given to anybody, the person is allowed and entitled to waive that right. So for you to say, respectfully, for the Supreme Court to say that it cannot be waived, I'm of the view that it's clearly wrong. And they need to reconsider it because it's totally against common sense. Now, I could not understand why the Supreme Court so held as it did. Now, there was another issue that was disturbing, and that I got, after reading from the supplementary affidavit, I thought it's unbelievably shocking. And what is it? How is it that, or it turned out from the affidavit, that the complainant, whose complaint is the subject of inquiry by this committee, have chosen not to give evidence themselves. And yet, the committee says it's okay. They can call witnesses. How? The complainants themselves, he who asserts must prove in criminal matters. This is more like quasi-criminal, because it's not an ordinary civil matter that you can choose or you can elect not to call yourself as a witness. This is a quasi-criminal, alleging the Chief Justice to have committed a wrong to the extent that he is potentially going to be removed. And you are saying the complainant has the right to elect not to give evidence? What kind of committee hearing is this? This is unbelievably shocking. It's not an ordinary civil matter where we say civil matter in civil cases, the person asserting doesn't need to himself or herself give evidence. No, this is a criminal, quasi-criminal. You are saying the Chief Justice has committed the wrong. And you are saying the person who is alleging that the Chief Justice has committed the wrong doesn't need to give evidence. What kind of system is this?
Okay, so
yes,
so I get your sentiments, and anybody who is who has a little understanding about rights and laws and all that will know that what you are saying is quite on point. That if he who alleges must prove. So if you are the one alleging, you must prove. But I read the affidavit in opposition by the Attorney General's Department to this application by the Chief Justice, and they seem to make an argument that the rights of the Chief Justice is intrinsically linked to the rights of the entire judicial service or the entire judiciary, and so she cannot be asking to waive her rights because the waiver of her rights will affect the rights of the entire judiciary. Can this attempt to marry the Chief Justice's rights to the rights of the entire judiciary be entertained?
Absolutely not. And look, I must confess, I have never seen the affidavit of opposition itself. But if that argument was made, I think it's clearly wrong. You see, it's not the entire judiciary that is at stake. It's the Chief Justice that you are alleging has committed the wrong. You are singling the individual. You are not suspending the whole office per se. But you are suspending the individual who is occupying the office. So you are making her rights, her inalienable personal rights, is now in at stake. So that position is not tenable. I am of the view that those who agree with that position, they are clearly wrong. Because when an individual is the subject of an inquiry, you cannot make it a collective right. So are they going to say all the judiciary is now going to face the inquiry? Is that what they are alleging? Is that what they are alleging?
Well, that is an interesting question to ask. I'm actually trying to figure out from the exact portion of the affidavit in opposition where they said that.
That's what I'm saying. That's what I'm saying. If that argument or that supposition was made, then it's a very, very erroneous position to take. But, of course, the Supreme Court has spoken. I disagree with it vehemently. I'm of the view they are wrong and should not have happened. Now, next one is a clear case of conflict of interest of the acting CJ. The acting CJ is benefiting from the position as acting in a position as a result of the woman being driven out of office. So even if the acting CJ is going to be so honest and so unbiased, even the perception of him benefiting alone should be enough for him to say, oh, okay, I'm stepping aside. The perception. That's why you go back to not only must justice be done, it must also be seen to be done. The acting CJ is now acting because the Chief Justice is not that she's sick or she's unable to perform, but she's been driven out. You are a clear beneficiary of this. And yet you choose to sit in all the matters. And consistently you choose to vote against the Chief Justice. Come on. If you don't know what conflict of interest is, this is a clear case of conflict of interest. The Chief Justice, acting Chief Justice, should not be sitting. Because the moment you keep on sitting and you keep on consistently vote against, it tells you have an interest. And if you don't believe you have an interest, the best thing for you to do is to step aside and get other judges to determine the matter. So these are matters that I was concerned. Because now they are saying, in effect, from the rulings that have come to the court, from the courts, they are saying, now the committee can go and be a kangaroo committee. They can do whatsoever they want. And there's no remedy. And it's not even, their findings is not even appealable. What kind of country is this?
Okay, so
if they go and hang the Chief Justice, that's the end of the story. When they go and they breach all the natural justice principles, that's the end of the story. And you're living in a country like this and you're happy. I'm not.
Okay, so paragraph 10 of the affidavit of position reads this way. It says that in further response to the deposition in paragraph 18 and 19 of the affidavit in support of the motion, the Attorney General states that while the applicant may be entitled to waive her rights, if any, to the protection and safeguards offered by the in-camera hearing, the applicant, being just one member of the constituents who are offered this safeguard and protection, is not in any way entitled to, and therefore cannot waive such rights to such protection or safeguards for the entire judiciary or potential witnesses in the matter. So this is paragraph 10 of the Attorney General's affidavits. Yes.
Look, it's absolutely laughable. So if the Chief Justice goes to the committee and says, I'm waiving my right to cross-examine any witness, are they going to deny her that? If she goes and says, I'm waiving my right to even participate in this hearing or this committee hearing, are they going to be able to deny her that? Because it's not only about her, but it's about the entire judiciary. That's an absurd supposition to make. Very absurd. You see, it makes no sense. And I think I'm quite surprised. You see, future posterity will judge all of us to see who is right. I'm of the view that this position of the Supreme Court is clearly wrong. It should never have happened, and it should never have been done. Unfortunately, I respect all the judges there, but I'm surprised that they brought this judgment or this ruling over the week.
Okay, Counsel. So before I let you go and then I come to the studio, from what has transpired in the Chief Justice's matter, I want to quickly find out from you, do you think there are any other remedies that accrue to the Chief Justice domestically, or you would recommend that the Chief Justice looks beyond the shores of the country to seek justice?
No. Look, I don't like washing our dirty linens outside. I like to wash our linens inside this country. Let people know that what is happening is wrong. When the Chief Justice go elsewhere, outside the divisions of this country, the whole reputation of our justice system will be brought to question. And I'm not of the view. But I would say, whatever the outcome of this committee is a done deal, signed, sealed, and delivered. The Chief Justice is not gonna come back, because I hear some absurd information recently, over the week, that even one of the witnesses that Daniel Ofori, one of the petitioners, was seeking to call, is Justice Kwamai, and yet Justice Kwamai is the one who is chairing the committee. Can you believe this? This whole thing is a joke. This whole committee thing is a joke.
So Justice Kwamai is the one who authored the judgment in the case of Daniel Ofori versus EcoBank. So he was a member of the 5-member panel. He was quote unquote like the junior on the panel, and so he authored the lead judgment, and that judgment went in favor of Daniel Ofori. I have had occasion to read that particular judgment, and ordered that EcoBank should pay an amount of about 6 million cedis with interest to Daniel Ofori and all that. So I'm not surprised that this is what you are coming up with, Counsel.
No. What I am saying is, I've heard this week that Daniel Ofori, the so-called petitioner, is seeking to call Justice Kwamai as a witness in a committee that is chaired by Justice Kwamai. What is this? What is this? Are we in Ghana? In a committee, so now they may decide, okay, we are not even going to call our witness after all, because our witness happens to be the chairman. What is this? What kind of country is this?
Okay, so these are questions that must be answered. Anyway,
are you not concerned as a citizen? Are you not concerned as a citizen? Tomorrow it will be your turn. When it came for the socialists, everybody kept quiet. And it came for the communists, everybody kept quiet. So you are quiet now. Are you not concerned? Tomorrow it may be you. And I think you remember how I began with, do unto others as you want them to do unto you. You remember what I said?
Indeed. Yes, I do. I remember very well.
Thank you.
Okay.
That is what I'm hinging my arguments on.
Okay.
It's just completely unacceptable.
Okay. So
if I were the Chief Justice, I'll just tell them to go to hell with their committee. They should just do whatever they want to do.
Okay.
Because their fate is signed, sealed, and delivered. Full stop.
Okay. All right. So interesting thoughts there. But quickly, the issues about the arrest of Bernard Entwibuesaku. The Constitution clearly says that if you arrest somebody within 48 hours, present the person before a court. But we are seeing a trend. It happened in the Edubuahin case where he was arrested, and then the arresting authority said that they have granted him bail, but the person couldn't meet the bail conditions. And so because of that, they continue to hold on to the person without presenting the person to the court. I just want to pick your thoughts. So if an arresting authority arrests an individual, and then within the 48 hours gives the person bail, and the person is not able to meet the bail conditions, does it waive that constitutional duty imposed on the arresting authority that within 48 hours present the person to court? Just by merely giving the person bail, it takes away that duty imposed on you to present the accused before court if you are keeping the person beyond 48 hours. I want your thoughts on that.
No, the answer is no. It doesn't waive the rights enshrined in the Constitution. It doesn't. However, you have to initiate or take an action in a civil matter against the Attorney General and the government. But you see that by the time the case is litigated, 3 years would have passed. And it's up to the judge to give you the remedies, the damages that you seek. And I'll say I have had a personal experience with this. I have tried some cases. I won in the end. But the judge just gave me some ridiculously minimal amount of 15,000, and I thought it put me off. Now, any time I get any police brutality, assault matters, it comes to my mind. The judges don't even understand why they should send a very high amount of damages to send a message to the department. You don't understand it. They award some ridiculously minimal amount. And I find it troubling. Now, we have to understand that bail is not intended to be punishment. This is what we get wrong in this country. People think you can use bail as a punishment. It's not the purpose of bail. I don't know. They've taught us several times, but I don't know the police. Maybe I don't know the training they give them. Bail is never, let me underline this, is never intended to be punishment or to be used as punishment. Because the person arrested is innocent until you have proven that he's guilty. So if you start punishing the person before he has been found guilty, that is unlawful. So when you set a bail ridiculously high, it means you have refused the person bail. The object of bail, I repeat, is to ensure that you come to court to defend yourself against the allegations leveled against you. Full stop. People just don't understand the basic principles. The principles is whether the charge that the person is facing is likely to come to court and defend. That is a simple analysis of bail. And where the person is a flight risk, say he doesn't have a fixed place of abode, in ordinary language means he doesn't have a place he lives, he doesn't have any family ties, he doesn't have a wife and children, the likelihood that he will be seen again, he will just melt into the country, in the system, and he will not be found. People like that, you want to be sure that if you give them bail, they will be found. Are you there?
Yes. I'm listening to the education. Please go ahead.
So when you look at somebody like Chairman Wontumi, with all his businesses, with all his with all his radio stations, with all his connections, with his position as the chairman, you ask yourself, what is the likelihood that this man will run away and he will not come and defend? So you say, okay, look, we'll give you bail, but bring your passport so that we can be sure you cannot run away. That's enough. Because if you want to make sure that the person doesn't run, you just take his means of traveling and you let the person go. Because you know that the person will not run away. But the moment you set the bail so high, you have presumed that the person is guilty and therefore he will run away. That's where most law enforcement agencies get it wrong.
Okay, so lastly, and this is the last one, and it's the last one because, there is this tendency or this growing concern that our investigative bodies are painting the picture that without the subject matter of the investigations that they are doing, they are unable to complete their investigations. And so, by all means, if they are investigating someone, they must get hold of that person, keep the person, and then try to get their details from the person they are investigating. But quite frankly, that person has a right to go before these committees and just keep quiet. Would that affect their investigations? The question I'm actually trying to ask is that how material is a person you are investigating to the investigations that you are conducting, such that if you don't have that person, you say you're unable to conduct your investigations. And I'm saying this on the strength of the recent investigation that was conducted by officials in the US on the mayor of New York. There was not once of a record showing that he was arrested or detained, but they completed their investigations, charged him, and then they made it public. Is there something similar that should be happening in Ghana, or our system is so porous that by all means you must get the victim or the accused person before you can complete the investigations?
I was going to say that we should get all our institutions, such as YOCO, BNI, or NIB, and the rest, we should get lawyers to be there. But see, then on a quick reflection, I said not all lawyers even understand what is going on. Because my good friend, the chief, was the special prosecutor, has been making the same mistake. Because he thinks the moment you are an investigative body, you have the power to yourself to do whatever you want. No, he doesn't. The same thing. Now, when somebody has been arrested, the first thing that should ring into your mind is, are we saying he's guilty or the law presumes that he's innocent? Now, what type of investigation are we going to conduct? What is the likelihood that the accused person is going to interfere with the investigation? These are matters that you can quickly, within 5 to 30 minutes, you can easily conclude on this without the need to go through all sorts of things by detaining the person and say, I'm giving you 15 billion. On what basis? And you see, the funny thing is, these people have not even been charged with any offense. So we have a situation where the person has not even been charged, and yet we are setting ridiculously high amount of money as bail, simply because in our local language we want to keep the person less. That is not proper. So I'm of the view that interfering with investigation itself is not enough for you to refuse. You see, then you should refuse the person bail and let the person know that he's been denied bail. Because, in essence, setting the bail so high that he cannot meet amounts to refusal.
All right, Counsel, I really want to thank you for you spending this time with us on Asaase Radio and for bringing us all these insights. I thank you very much for your commitment to Asaase Radio. We are very grateful. So that is Kwame Adolfo. Kwame Adolfo is a lawyer in private practice, always responds to the calls of Asaase Radio, and we are grateful indeed to him. All right, so let's come to the studio now, and we've also been joined now by Alex Gyamfi. Alex Gyamfi is a lawyer in private practice, and he's also a friend of Asaase Radio. He has also joined us this morning. A very good morning to you, Counsel.
Good morning, and thank you for having me.
It's good to see you.
Yes, sir.
All right. So let's come to the studio. And Dennis was here earlier. So Dennis Ofori Esiedu is also a lawyer in private practice, and he's a member of the National Democratic Congress. Good morning to you again, Dennis.
Yeah, good morning, Wilberforce.
All right, Dennis. So there are concerns that your party, and for that matter, the government, seems to be targeting opposition members and arresting them and detaining them contrary to the provisions of law. The first was some raids in some people's homes, Ken Ofori-Attah's home. Subsequently, the former governor of the Bank of Ghana. Then the arrest of Kwabena Edubuahin. Now the arrest of Chairman Wontumi. And all of them seem to be taking the same style. What do you have to say to that? Is it an intentional thing, or there's so much that the government must by force do the things that it's doing? Just before you answer, Domenyo says that it's the constitution cast in iron, okay, that no provision in same cannot be set aside in the case in the case in question, which is talking about the Chief Justice case, is man-made for the constitution or the constitution made for man? And that is a question that Dominia is asking. And Eddie Mensah is saying that, good morning, Wilberforce. For me, in all of this, it is the silence of the CSOs that speaks volumes for me. And we'll talk about the CSOs. I think most of them have appointments now, so they are busy. They don't have time to be commenting on such issues. All right, Dennis.
Wilberforce, thank you very much for the opportunity. And let me say good morning to my
your senior.
Yeah, sure. No two ways about that. But understanding of the issues will always depend on the individual and how the individual appreciates what is going on. Arrests of an individual is not dependent upon a particular government or a political party's ideology. The mode of arrests are laid down and there are institutions that are responsible for same. And so depending on how the institution views the individual they seek to arrest and the circumstances surrounding the individual, it will use a particular style or strategy in arresting the person. You see, when, let's say, the police force decides to arrest a person like me, they can just walk in here and invite me, or just say you're under arrest for ABC and go with me. Nobody will fight them. I won't resist. Nothing will happen. So let's take the last one, for instance. The last one you seek to talk about. There was an initial attempt to arrest the person from his home. You saw what happened. He himself created the impression that his home has been invaded by some men who have come to his home in a Rambo style and was inviting people to come. You see, when people mass up around your home, when the police seek to pick only one person, it will resort to violence. That is what it will be. And so you don't expect the police or the other security agency that seeks to pick the same person up to go to the same home to attempt to arrest the person. And so they will adapt a different method. So when the opportunity came that he has reported to the police headquarters or CID headquarters, the Yoko decided to take advantage of the situation. Mind you, we are creating the impression as if he was just arrested without anything. Yesterday, I heard his counsel saying that they came with a warrant to arrest him. And so sometimes we don't need to be partisan or to stand on the side of a particular political party to state certain views. The man has created the impression in the eyes of all of us that should the Yoko come to his home, he will create the same atmosphere he created when the NIB, or was it the police, attempted to arrest him the first time. And there's an investigation going on. Look at the actions of our brothers, the minority. If you were in the shoes of the Yoko, will you just allow the man to go? You've picked him up peacefully. He's in your custody. You are not molesting him. You are not denying him bail. You are not harming him. Even when he got to the Yoko premises, he said he was unwell. He was taken to the hospital. Yet, look at the way our brothers are behaving. Burning ties.
Burning ties?
Oh yes, the first night. You mean you didn't see that?
You mean the minority was burning ties? Or
when I say minority, I'm not referring to minority in parliament.
Okay.
I'm referring to the minority party as it is now.
The opposition
party.
All right.
And when I cap it opposition, I might be referring to other parties, but I'm talking about the NPP. I'm talking about the New Patriotic Party.
All right.
Look at the way they are behaving, to the extent that persons are alleging that they give them money on the streets to join them, for the numbers to go up, to create the impression as though there are many. That is not how things should be done. Let's allow the institutions to work, because just some 6 months ago, we were not even allowed to talk.
In Ghana?
Oh. We were forced to don't act as though we've not been here.
Oh, no, I was talking, so that's why I'm surprised.
You were talking, and you see, you were talking, but you've become even louder. and you can see and also see persons who are not talking because they've got some work to do, and that is good. That is impressive, because you are just saying that at a certain point they didn't have anything to do. They had to talk, and they were not talking because they were not allowed to talk.
Oh, really? People are saying that those people used to talk. So Eddie Mensah, for example, is saying that good morning, Wilberforce. For me, in all of this, it is the silence of the CSOs that speaks volumes for me. So he's trying to say that previously the CSOs were very loud. We saw people like Professor Jampo during the Kufuor administration. He was speaking everywhere. He was tweeting everywhere about everything. So
has he really stopped? Has he stopped talking?
He's busy.
No, he's busy working.
Yes.
He's busy working because now more or less he's doing two jobs, because he might still have to deal with the students or backlog of school work.
He's on sabbatical leave from the university. But once you are working in a different space, you have to be on sabbatical. So he doesn't teach anymore.
No, but what happens is that usually you have a backlog that you need to clear.
Maybe marking scripts.
Marking scripts and releasing results and all that. We've been in that space before, so we understand. But what you see, you can't put the blame on them as you are trying to do. What is happening right now is that people are free to do the things they were not allowed. You know, in the past, just in the recent past, certain things happened that did not happen previously. And so when I hear my seniors talking as though all the things happening are things that have just started happening, I'm surprised. And the painful part is that they conclude by threatening, quoting, "Do unto others what you wish others to do unto you." That is biblical. That is good. That is religious. But did they practice that? They did not. And so now, if we are seeing something like this and they are crying wolf, what it means is that it is rather karma that has caught up with them, and that is what is hurting them. But that is not to say that we should live in a tit-for-tat environment. Look, I used to work under the late former chairman of the NDC, Dr. Kobrenje. Okay, so he told me something. He said, "I've been in the government space or political space from 1982. That was like a year before his death. He said, "I've been in the political space from 1982. And governments have changed. Have you heard at any point that have been invited for questioning before? So why have you not been invited? Wilberforce, why have you not been arrested? There are others who were in government as well. There are others who were also party chairmen. The MPP has about 16 regional chairmen. There's a national chairman. There's a general secretary. Why have they all not been arrested? So why are we acting as if there is some witch hunt going on? Let's allow the institutions to work. And me, I've not seen anything wrong, because if it was a witch hunt, it would have started from Justin Kodua, Stephen Ntim. They are the top. Nobody will leave the top and go to Ashanti region. What? Why? It means that there's something going on there. And let's allow the Yoko to work.
Okay, so I was going to I wanted us to structure this conversation, so we do with the Chief Justice and then we come and do with Chairman Wontumi. But it seems that we veered off and went starting with Chairman Wontumi.
You pushed
but yes, I pushed you there. Yes, I understand. But I will bring us back to the Chief Justice, and then we will come to the Chairman Wontumi. But you know that when you were talking about the fact that only 6 months ago people could not talk, there's no example of that situation where you say nobody was talking, because our airwaves was full of everybody sharing their thoughts. In fact, the records are showing that in the last 2 years in our country, the airwaves have been very polarized than ever in the history of the country, the last 2 years. And that was because the then government allowed everybody to share their thoughts. And you share unless you were saying something that was against the security of the state. But in terms of, we have examples. You have so many examples to share. Even people who are outside the jurisdiction were speaking into our jurisdiction, and we were encouraging them and motivating them. So really, that claim that people could not talk, and now that people are talking. In fact, it is now that people are saying that if you talk, you are gagged. It's now. Now, that's what people are saying. Anyway, so let's come to the Supreme Court and the Chief Justice matters.
Yes. You'll be unfair to me if you don't allow me. You see, we had a private conversation when I entered. How did we get to that private conversation the two of us had? The question you asked me, how did we get there? Was it not as a result of just gagging? Was it not as a result of unfair treatment? I don't want us to even go there. The conversation we had.
That one has to do with,
it's a privilege.
It's a privilege.
That's why we are not mentioning it. But I'm saying that if it says,
I don't think it has any bearing on what we are discussing.
No, it has.
Because I think it has to do with an internal matter.
Disclosure.
Yes.
Disclose the full details of the private conversation.
No, it had to do with internal NDC matters. So I don't know how you are trying to connect it.
Don't worry. Okay. I'm saying that it is because persons tried to gag other persons. That was what took us there. But thankfully, now we are getting out of that space. So don't let us even go back.
Go back there. Okay. All right. So let's come to the Supreme Court and the Chief Justice.
Deal with this matter.
You want to deal with it? Okay. All right.
We know that.
Okay. So I think we should continue then, and then we'll come and talk about it. Yes.
In all respect to my learned friend, that in this country, in the last 8 years in the Akufo-Addo administration, however you disagree, we were gagged not to talk. I respectfully, my brother, where were you when people demonstrated to the governor of Bank of Ghana, the conduct of Susu and other people? Where were you? What hasn't Oliver done in the last 8 years in Ghana? Oliver, my own friend, my own contemporary. Where was my learned friend? All the demonstrations the NDC went through, the Jubilee House thing, and the conduct of the young men who seized the road, 37 road, and were playing football. Doesn't listen to the NDC radio stations, assuming that other people are not being asked to talk. Was he listening to them in the last 8 years? The Muntie group that regrouped into Power FM. And that any other person in the last 8 years under Akufo-Addo regime, radio station, television, was arrested for expressing a dissent. He never cited one example, but I think I've given him 3 or 4. That any of these radio stations and anybody in Ghana was prosecuted for expression, free expression. You see, you may not like once you are an opponent. You may not like us. But when you turn the truth the upside down, I have seen it and witnessed this morning, it's really disappointing. No, let's be fair. I am not a member of the NDC, and I have friends in the NDC, and we talk.
Interesting.
You see, the things we are complaining today, we are not complaining these things for nothing. For example, the arrest of Wontumi and all the things. If you are dealing with a person from the NDC tradition, Will we sit down quietly to be arrested in the manner when we know their forefathers, how they arrested judges from their homes and did what the most impeccable thing, the unthinkable thing in the Ghanaian history, murdered them and burned them. So if you're an MPP person and there's a change of government and NDC is arresting you, why won't you be conscious? Rocco Frimpong suspects were detained 400 hours under Professor Mills, a law professor. 400 hours. In the end, they were mere suspects. What happened to the trial? Bazaar. Me, I am opposed to pre-trial detentions. If you cited the best example of the New York governor's case. And the most disappointing thing is that these things are happening under Ayene. Ayene is one of the proponents, those days when he was our teacher, proponent of him, and he was taking NDC members on. I remember under Mills. Yoko was headed by this lawyer, Mota Akpaji. And Mota Akpaji was mistreating people. I remember my own friend, the late John Kuma. What the hell he went through. And Ayane was our teacher who would then come to class to complain that these are the things that if we're law students, you should be interested in. Exercise of power by state institutions and administrative bodies. If Mr. Wontumi had done anything wrong, no problem. If we say we want to make it better than we met it, don't we advance what is honorable and principle? And then lawyers tend to argue as if the state of affairs must exist status quo as it is. I have never seen it anywhere in my teachings and my practice. That I accept a status quo because it was done A or B. That is why we test the law. So in all respect, if Ayene is the Attorney General today, and the very things he complained to us and asked us to learn and to resist it when we were students under his watch, he becomes Attorney General. He was one of the persons who was appointed Attorney General. That I hail him. That I thought strongly that he is not a person you can use politics to turn his understanding of the law. But since he came, look at what is happening. The raiding of the governor's home. What was the basis of it? What have we been taught? After all, he had been going through press conferences. I have not seen that before. That where you want to deal with people when you come and finish them in the press before you go to court. I have never seen and read it anywhere. Then you go to Kwabena Eduwahin. Then you go to Ofuriate's home. Under him, he may not necessarily be responsible, but it is happening under the regime in which he's the principal legal advisor to government. So we should accept what Mr. Wontumi is going through and keep quiet. What is the basis of all that has happened? And the power exercised by administrative bodies. I mean, don't we know how discretion should be exercised? And having several times that organization have been told that where anybody exercises a discretionary power, he must give guidelines on how such discretionary power should be exercised. What has happened to 48-hour rule in the Constitution? To the extent that director of Yoko, a journalist, could determine your fate and ask you to bring $50 million property. What is the common sense of this? If not to show people, as the lawyer said, our friend Kwame Adofo said, to show people who they are. And so if I tell you that with the table 10, you will suffer the same thing. You are talking that we are being biblical and we are talking too much. Is it not the same people you have subjected me to? I don't favor an eye for an eye because it will make all of us blind. But on a fairer note, in the last 4 or 3.5 months, what has transpired? It doesn't give me confidence that we are in a secure democracy. It doesn't, because no sane person will agree with what is happening.
Oh, senior.
With the greatest of that's my choice of words. No same person. Of course, it's relative. It's relative to you. But the question is that you being a lawyer and all the other people being lawyers and who are presiding over this, what was their views when similar or something like that happened to them? Tell me under what circumstance in the last 8 years anybody in the NDC was told to bring 50 million for investigation. Not even a convicted criminal who is staying outside. Sedinam Tamaklo. What happened under Sedinam Tamaklo? Is it the treatment we subjected her
As
to?
they said, the now Tamaklo's bill was pegged at 5 million Ghana cedis.
5 million Ghana cedis.
Yes.
Yeah.
In spite of the amount of money he was alleged and convicted to have
the
stolen.
bail bond. 5 million Ghana
Ghana
cedis.
cedis.
What was William's bail bond?
We can't wait myself. You embarrassed by the way.
Oh,
It's the worst in the same person.
No, you said.
William.
Oh, leave that, senior.
Okay, no, wait, hold on.
I'm being hard.
On the
I'm being hard because you never cited one example.
Oh,
So
wait.
On
You said
this show, we
mention
allow
one.
people to talk when it's their turn.
No, but he invited me to mention
I
one.
invited
And
you.
said,
I sat
what
here
is-
quietly.
I said, what is William's bail bond?
You don't mention William's case right here.
What was Women's with bail bond?
Bail bond.
Who just siphoned money from the state with the support of people in the senior office of the NDC. You understand me, my brother? So I am being passionate here because you don't compare apples with oranges. Compare the values that they say. We call it philosophy, we call it permutation. But this permutation, it doesn't gel. My worry is that you made this allegation without citing one person. I've cited over 6, and I'm saying they're citing Tamaklo. If you are researching and are looking for people who have looted the state, is it not best to bring the person who has already been convicted? But of course, why do you expect this from them? When indisciplined things have gone on and wrong things have gone on, people are facing the law. They came to set them all free. To be looking for fresh, alleged, quote-unquote, what? Criminals. This is the democracy we find ourselves. So you can see how even the most senior judge will not be secured. The most senior and the most distinguished judge, judicial officer in Ghana, hear the argument the court made when my learned friend, we will come back to it when my learned friend alluded to it, that the reason they read is what we have been taught in the law school. The reason the Supreme Court justices gave this week, we are waiting for the full report, is what you were taught in the law school. May God save the Republic.
Okay, so very, very passionate issues. But Dennis, when you were talking about this whole issue, you made mention or you made use of the word karma, and there's the tendency for people to say that if you refer to these happenings as karma, then you're actually trying to say that karma has a place in the democratic experiment that we are exercising. But should it be so? If you are a respecter of democratic principles, it does not matter if your opponent disrespected it. Because you are democratic, even if somebody disrespected it, you will respect it because you are democratic. So why are you going the route of karma?
I said maybe it is rather karma that has caught up with our friends. You see, Wilberforce, at least I'm a bit old, so I've seen a few things. When President Mills won election, he did something, and what he did was that he said, "Don't touch anybody. Let the people be. Let's all come together." And he named himself Father for All and Asumdwehene. And he received a lot of passion from his own party people, that these people dealt with our people when President Kufuor was president. Why are you letting them off the hook? You know what happened? When Nana Addo won power, our friends said we did not prosecute anybody because there was no corruption during President Kufuor's time.
No, but in the Mills time, people were prosecuted. I mean, you cannot say that
political cases.
there were political cases in the Mills time.
I'm
Yes.
coming.
But
Do you remember the phrase "Father for All"? You do.
No,
It's a
right,
political
of
thing.
course, it's a
And
political.
And so-
He says he was
no,
Asumdwehene.
he was Asumdwehene. He was Father for All. And so some of the things you are referring to today, we did not see them. like asking people to even proceed on leave. It was President Kufuor's time that he came. President Mills did not let it happen because he wanted to see a change. Now, when Nana Addo came, worse things happened. So, should it be the case that it is only when NDC comes to power that we see our brothers?
So which worst things are you saying happened? Because you know Woyome that you mentioned, Woyome was charged under the NDC. He was not charged under the NPP.
You see, Woyome was mentioned
and
in
his
reference.
bail bond was about 54 million Ghana cedis under the NDC. It was not under MPP.
And we must find out the relationship between women and Ramonacha. Ramonacha, the Yoko boys now.
That is not the
No, you are
issue.
shifting the debate into NDC.
No, we are talking about we are talking about bail bond. You were making reference to bail bond, and I reminded you of a bail bond in the past.
5 million.
He just mentioned
when your own government
mentioned
gave you bail bond of what? They were charged of what? I think 54 million.
Yes, the Woyome was under the NDC, and the bail bond was 54 million, but it was not under an MPP.
So I'm saying that there's precedent to the amount or the bail bond that has been placed on Wontumi. And so when you create the impression that Wontumi is somebody on who we cannot place a bail bond of 50 million because it has not happened before, I don't get it. That is my point. My point is that I don't get it when you say that it has not happened before. He's the first person who has been slapped with such a bail bond. It is not a fact. Whether it was during the NDC's time or MPP time, it has happened before.
So Iyoko gave Edubuahi 120 million Ghana cedi bail, and then later on his lawyers went to the court and got it reviewed to 80 million Ghana cedis and all that. That should be a source of worry if you are giving this high bail bonds and then it goes to the court and the court reviews it. Shouldn't it be a warning to the Iyoko team that look, they are probably going beyond the confines of the law or the space within which the law allows them to do some of this? Shouldn't it be a matter of concern to them?
Why should it be? It depends on how much they suspect to have gone to you or what they are investigating. So if they are investigating over, let's say, 200 million and they give you a bail bond of 50 million, it is just about 25% of what they are investigating. And so I don't see it to be something overboard. And besides, counsel will tell you that is why we have the court. When you feel that something is not properly done, you go to the court for a review. And Edubuahi has taken advantage of the situation. Wontumi can also take advantage of the situation, go to the court for it to be reviewed.
Okay, so counsel, he was talking about the fact that under Professor Mills there was no such prosecutions and all that, but at least my small memory tells me that under Professor Mills various things happened. I mean, I remember the Asamoah Boateng prosecution. He went through the whole process and then the court found him not to be guilty. There were several others. You have a lot of institutional memory. You can inform us about this.
I think again my brother did not cite any example. And so this idea of father for all was their own creation. So that as we say in our local language, I want or cows so not saying who. So you don't feel the pain. Meanwhile, he's stretching you out to the extent that he's even putting the rope on your neck, hanging you virtually and taking your life. What did Professor Mills do? Even he who was a law professor. And we thought that we would probably get the most secured tenure and protection of our rights. It is not to say that to take a person to court is wrong, but to create the impression that he was a father of all and therefore he wasn't acting hard enough and your people were complaining. It's neither here nor there. I remember 18 cases. You remember the former board chairman of the ADB, the late Jima. You remember the former foreign minister, Akwesi Oseje, over something rice. You remember Asamoah Boateng. You remember Frank Ejekum, Kojom Pieni and Rekum Brobe, Ghana 50. In the end, the result they found in Ghana 50, they themselves were ashamed because what they suspected to be was wrong. Woyome, they set up a complete committee under the late lawyer Wono and did all manner of things without talking to Kodum Pinim and anybody. After wasting money and paying crooked money to themselves and pocketed the money, when the issues came up and Kodum Pinim had to speak on Newsfile, that was the end of them. That was not embarrassing enough to them. This is their record. What did the Akufo-Addo do that you people didn't have the opportunity to challenge it in court? Tell me. We know people who went to beg. The Akufo-Addo's mistake that the party he has brought there to this state is one of them. The double salary thing where ministers and members of parliament of the previous regime went to beg. And the president exercised a discretion for them to pay. Today they are the ones who are prosecuting and challenging.
But did they pay?
I don't know.
There is no record.
But they said they went to beg.
Yes, the begging.
So
remember.
they took the two men, the two salaries, pocketed up to today, and today they are telling probity and accountability. These are the people who are teaching the probity and accountability.
Do you remember that?
It is part of the record that party people are not happy with the Akufo-Addo, including myself. When the issues were clear for some purpose trial, what happened?
You remember when Professor Mills?
What did he do?
What happened?
What did he do?
For some purpose trial.
What did he do?
What happened? Today.
You mean the former chairman of the NDC? You're asking what did he do?
What did he do?
Oh, really? You don't know what he did?
You see? What did he do? So you see, the problem is that when you allow these things to go without explanation to the party base, the disaffection is what we saw in the outcome of the election. And it shall be part of the Akufo-Addo's record. The party people will never forgive him. The party people, including myself, have never forgiven him about that thing. When he allowed them to go in the name of human rights protection and those things, today look at the record they are putting up.
Okay, so you know that it's on record that when Professor Mills became president,
people went to court. They won. Asamoah Boateng, the aeroplane was grounded. Asamoah Boateng at the airport, he was traveling with his wife and two daughters or so. The remain was under Professor, the watch of Professor Mills.
I think he was prosecuted together with the wife.
In the end,
and both of them were found not guilty.
What happened?
Okay, but it's under the same.
So they won't do their work well. They will show you power. They won't do their work well. Look at the things they started and look at how things are going. We cannot prejudge issues, but from their background, from their history and prosecution, you can see clearly 18 cases under Betty Idrisu. What did you get? Nothing. Waste of state resources. At least we got something against Sednam Tamakulu. You have assisted this same person to run away.
Who assisted them?
Who were the people who signed the bill? Who were the people who signed the bill? Tell me. Whether they were the chief members of the NDC. Where were they?
No, who are they?
Alex Mould. Alex
Mould was one of them. Now the woman went away.
Yes.
Has he come back to face justice?
Okay,
if you are looking for people who have robbed the state, is it not fair to bring that person also back to come and face justice? My point is that let's be fair to everybody. And once we are lawyers, we don't just accept the status quo because it's been done by a political party or for your interest. You accept it based on the law.
Exactly what you are doing.
What did I do? Our people faced the prosecution. They went through the mill. Is it not going through? Have we stopped or have we said it's bad? It is bad if you get people who don't really know the due process. But at least as I know the due process, we question about the proprietiness of that thing, not necessarily that you have taken it to court. But why won't you respect the law? In the case of Wontumi that we are talking about, we talk about 48-hour rule. So why would administrative officer keep the person more than 48? And my worry is that what the lawyers for Wontumi, why haven't they gone to High Court?
I think that now there's a case that has been filed at the High Court, which is supposed to be heard on the 2nd of June. Yes. But I was just trying to draw your attention to the fact that it was under Professor Mills that Professor Ken Atefa was removed from the NIA because
he's saying that people were not sent to proceed on leave.
Yes, but because he didn't have the ideology of the NDC, and it was the same Professor Ken Atefa who had to come back and
they put their direction, their own director there. Their own director, Professor Haji. What did he do with the Ghana card? That he was able to produce even a standard one Ghana card. So much money that was given to the organization. Eventually, Tefa came and registered and did Ghana card for more than 16 million people.
17 million.
That's it. So look at the end product, the record. The record speaks for itself.
Wait. You see,
you don't why
are you creating the impression as if Nothing was done at NIA.
Speaking about NIA, so do better. Tell me.
Wait. Why are you creating the impression as if nothing was
Were
done?
you giving card under Haji?
Yes, I was giving.
What card of that?
I was giving.
After how many years?
Card.
After how many years?
Wait. So when you come to replace what someone has given, it doesn't mean the person did not do anything.
17,600,000, which was not even.
Wait. I registered. I was given a card. So if you sit here and say not even one card was issued,
And that card, where is it?
That's
Where was the value of that card?
And what did you see? Values are placed on items by the state or the persons who are using it. And so if someone starts issuing cards and he's not done with it, and you win power, and you decide that you won't continue, you will change the nature of the cards. What have you done differently? If not, you just continue the process. Don't act as though you are the inventor of the whole process.
But who introduced the whole idea of Ghana card in Ghana? At least it came from John Kufuor. Even though the historical perspective, where Champon had mooted the idea in 1974, there should be something like that. 1974. 1974. Champon had mooted the idea. But he suffered from this his sanctions and those things against his regime, those things. But for real Ghana card to be making the case for economic development, you can take Jokovo out of it.
No, yeah. And you see, that is where we are all getting it wrong.
You are getting it wrong. Me, are getting it wrong.
You are even getting you are worse.
What is he getting wrong?
No, what we are getting wrong here is that governance is supposed to be a continuum. This one starts from here. Then this one will continue. This one will start from here. Then this one will continue. And so, you see, you can't say that once MPP is gone, everything that was started in their regime is useless.
That's not what you said. You have not said that.
Wait. So, if President Kufuor brought the whole idea of Ghana card, reintroducing the national ID card, the question is, after him, was it cancelled? Was it stopped? No, someone came to continue from that point to a certain point, and another person came to continue, and now someone else is continuing. That is how things are supposed to be. But don't make it look like when President Kufuor started, NDC came and did not even touch it, did not do anything, to quote your word, did not issue even a single card.
Probably they did very little.
They did not do very little. They did so much.
I'm told that throughout the period of the Mills Mahama administration, they issued 900,000 cards. Throughout the Akufo-Addo administration, under the watch of Professor Kenatifa, they issued 17 million cards. So 900 compared to 17 million.
No, wait. So when Professor Etifua came, what new items, more like the resources for the production of the cards, did he introduce? What did he really change? Those are the things you
well,
see.
Several of them. And I should just let you know that Professor Kenatifa is listening to this show. So anything that you say about him that is not right.
No. But
he has a right of rebuttal.
No problem.
He's listening to you now.
No problem.
Okay.
No problem. Right. That's no problem.
Okay, but I have a question for you. And the question for you is that a listener would want you to respond to a certain profound philosophical statement that was made by Mr. Alex Jemfi. Okay. And that statement has to do with the fact that an eye for an eye would lead all of us to being blind. So he made this statement, and he's here. He made it.
But I've responded.
You have not responded.
I have. I said that.
Yes.
I said that. We remember this philosophy only when NDC is in power. But forget it when MPP is in power. And you see, what even makes this one even worse is what he said after making this statement, that he does not believe in it. He said he does not believe in it. Fine. I may also not believe in it. May. But when you make that statement, trying to say that there shouldn't be an eye for an eye, and you end by saying that as NDC is taking these steps, they should remember that power
is transient.
is transient and will change someday. Yes. That is the threat at the end of it.
I'm reminding you of the fact.
Fine. So if you are reminding me, what it tells me is that whatever I have to do, I have to do it now, because when you get opportunity, you do what you did yesterday. So it is not for me to forgive you so that you come tomorrow and say that, oh, you it's because you are afraid of me. That's why you didn't do anything. But me, I will do it again. But that's Ronaldo said.
No, it's just to question you.
But just as Ronaldo said, so once there's some level of evidence that someone has done something, the law will have to
take its course.
When is Tamaklo coming to face the law? Since we are looking for,
I'm not sure he's able to answer that question.
Yeah, but maybe he will take it to his bosses.
Yes, I'm not sure you are able to answer that.
When is he coming?
I think it will be unfair for you to answer that because you are not the one
who should carry my message.
He's saying something.
No, he's saying that when is said in Tamaklo.
You heard it. Me, I did not hear.
You see?
Oh, you didn't hear?
I didn't hear his question.
Okay.
Can I repeat it?
No, don't repeat. Let's proceed.
Okay, so let me just bring our Facebook constituents into this matter. And I've seen several messages pouring out on our Facebook wall, and let me do well to read them. So we'll talk about the Supreme Court, but I've seen that Abdul Basit Mahama, my very good friend and co-host of this show, has been sending messages about the Supreme Court. So he's talking about the fact that the Supreme Court, in essence, appears to suggest that the fundamental human rights of the Chief Justice, such as the right to a fair hearing, dignity, and protection from arbitrary treatment, may be restricted, abused, or even trampled upon by a committee constituted under Article 146 of the same Constitution that guarantees these rights. This position, respectfully, is deeply troubling. And we'll talk about this deeply troubling arguments that you are making, Basit, in the second half of the show. All right, so the other statements here. Kojo Efie says that, good morning, Wilberforce. What is our NDC friend saying? This man is just making some interesting comments. So, under Nana Dankwa Akufo-Addo's administration, you can't talk. Mr. Man, please give us a break. And so people disagree with your comments.
They have a break.
Kwabena Jemfi says that how on earth can this NDC man say that people were not allowed to talk under Akufo-Addo? That is the sort of lies that the NDC spewed. Nobody was allowed to talk. Is their own hype. On which subject matter were people barred from talking? And that's a question that Kwabena Jemfi is asking. All right, Eddie Mensah says that Wilberforce, tell the man in the studio, we even had men of God insulting the former president Akufo-Addo on their pulpit. And so Eddie Mensah is saying that not only were people able to talk, but there were men of God who were using their pulpit to attack Akufo-Addo, and nothing went wrong. They didn't get arrested. Okay, so Professor Kenatefa has responded to you, and I'll read his response to you very soon. I told you he was listening. Samuel Ofosuba says that, good morning, Wilberforce, and your noble panels. At times, some of us who have foreign friends who are interested in the affairs and the happenings in Ghana make mockery of us in our discussion, as are the area of the recent socio-economic and judicial cases. Some of them do ask, does your government practice democracy or autocracy? The idea of my party is in power. I have to satisfy my party fellows. Will deteriorate our beautiful country into the future. Okay, so these unconstitutional forms of rulership will cause more harm than the so-called resetting. Would the NDC lawyer in the studio be satisfied if he is being treated as they are treating the CJ and the recent victims of their security officers? Okay, so that's a question that Samuel Ofosuba is asking you, Dennis, to answer, and I'll give you the opportunity to answer. President Mahama and his appointees must know that power is transient, and that is Ofosuba. Yes, I think Mr. Alex Jemfi has mentioned that earlier on today. And then Karma never forgets. The NDC will never be in power forever. Okay, that is Mr. Free's comment there. Christopher comes in and says that, good morning, Wolby. The current NDC government is hell-bent on tarnishing the image of the MPB and especially the past government officials. The painful part is not even the NDC guys and their party foot soldiers raiding the houses of past MPP government and party officials, but the way the MPP guys is so divided. The MPP cannot even coordinate their statements coming out of the Ashanti region chairman arrest. I feel sorry for the MPP. They look too divided. Okay, so Christopher, they're talking about the division in the MPP. President Nana has really damaged the MPP. Okay, so that's your thoughts. NDC has frozen Wontumi's bank account and then slapped him with 50 million bail bond. Is this justice? The man lives in Kumasi and you want bail bond property in the value of 50 million to be cited in Accra. Amazing. Was that the situation, Ms. Jenfi? You've not checked it. Okay. All right. So, okay. So other messages. Now the messages are a lot. So I'm trying to read all of them before we continue the conversation in the studio. Okay. So, Wilberforce, all this time, I know that the country had problems in education, health, infrastructure, unemployment. But the recent happenings in the judiciary is scaring me. The country is on slippery slope, heading towards abyss. The way we are behaving, I believe God is weeping for us. And that is assigned to Isaac's message. All right. And then last two messages. Wilberforce, please get the NDC representative. Oh no, I can't do that. Please don't go that route. He's here. Yeah.
They should appreciate that.
Yes, this is a democratic exercise. We are in a country of free speech. Everybody must share their thoughts. We will not gag anybody from sharing his thoughts. If we disagree with you, we can ask you to clarify. We can ask you to explain.
He's so used to the status quo.
Mahama is so this one says was Mahama is the who arrest Wontumi and not Wako or Mbia. I don't know what you mean by. I'm sure you are saying that maybe you wanted to say that Mahama is the one who arrested Wontumi and not Yoko or NIB. Well, Mahama did not arrest Wontumi personally. He was arrested by officials who are working and acting under his administration. But I don't think Mahama is the one who went to arrest Wontumi personally. He is nowhere involved in this matter, except that it is his officials, his appointees, who are carrying out this arrest and investigations that are ongoing. So Professor Kenatefa says I should tell you that NIA issued 900,000 cards in 2D barcode cards between 2009 and 2016. NIA issued over 16 million smart biometric ID cards in 1 year of mass registration. So that's the difference. Do you get it, Dennis? The professor is giving you the difference. Between 2009 and 2016, you did 900 cards in 2D. Yes, but in 1 year, when he took over office, they issued 60 million smart biometric ID cards. And I have one. Do you have one? Do you have a Ghana card?
Yeah, I have a
card. Okay, because I have one. I have one of the cards that was issued.
Take me to the bank,
yes,
to MTN, to pay everything.
Places.
Not the one you issued that could not even pay school fees.
Cancel.
Cannot be used to pay school fees.
No, cancel. You see, all the places that we can now take the Ghana card to.
Yes.
Did not just sit and decide one day that
1 year.
Did not just sit.
Don't let us make the issue Ghana card.
Bring me Ghana card. It was a government policy,
and we did better than you.
Register.
We did better than you.
It is work. It was work in progress, and we have
8 years. 8 years, 900,000.
Work in progress, and we have
1 year, 16 million.
Okay,
and the permutation.
You don't get it.
So let's end our discussions on this Wontumi matter before we switch over to the other. But Professor Kenatefa has sent me a document that I can share. He's asking me to share with you about the achievements of the NIA. So when we finish the show and I get your number, I'll forward it to you so that you can use it to refer to yourself in future discussions wherever you go. All right. So Wontumi should just exercise his right to remain silent, refuse to cooperate, demand good meals and seek medical checks ups and all that. Claim he does not understand the questions and require an interpreter. If Yoko has a solid case, this should stop them. So, Mr. Jenfi, and I need you to comment about this thing about investigations. And I asked Adolfo earlier on, when investigative bodies are doing investigations and they seem to go Rambo style for the subject matter of the investigations, making it look like without them, they are unable to do their work and complete the work. Really, I find that quite difficult. I don't know what we can do to change that, because it appears our security agencies, year after year, that is the model. They are always going after these individuals that they are investigating and seeking to detain them, keep them, and as if it is that effort that will make them be able to complete their work. Really, it shouldn't be so.
Well, thank you for the opportunity. You see, the act that established the particular office, whether it's OSP, EOCO, or any other of them, the act and its ally regulates how the business should be conducted. Don't forget that we don't live under a monarchy, neither do we live in under a military rule. I always draw inference and examples from the United States. When Trump started some of these executive powers and left and right, there were challenges from all manner of people that this is a democracy, it's a constitutional rule. To the extent that I think 3 or 4 days ago you saw that some of the tariff issue went to federal court.
Yes, the court has shut it down.
Yes. You see, that is where civility applies and the rule of law works. There is always the right to exercise a discretion. If you invite me to your office, the law is that you tell me why you have invited me, or even if you arrest me, why I have been arrested, what my rights are, and what I'm entitled to, and the purpose upon which the state needs me in such office. If you, as I've indicated, I am vehemently opposed to pre-trial detentions, because you give powers to administrative officers and they are likely, not possibly, to abuse it. So the question you pose, Yoko has police powers, CID has power, police has power to arrest. But if you can really show me that the person has not resisted arrest, lawful arrest, what is the essence of going there, marshalling people in full gear military protection as if, I mean, you are going to arrest a mere mosquito, and you go with guns and knives and as if there is some special operations? Those are worrying. Remember that this one, there is no hard and fast rules about it. We have had experience since independence, and we have seen how things have ended. We saw how young pioneer people told lies about people. They were arrested, detained, and all manner of things, and the commission of inquiries we saw after the overthrow of various governments. And the truth and the kind of things that come. We have come to the level of national reconciliation. We've seen all these things and we say, let us learn from them. So you see, it is the orientation of the people who run these organizations. It is also important for the government to show interest in the people he has appointed in doing businesses of this nature. Because I don't see, the question you pose, I don't see the hell and tail of it. That we have to go through such drama in the last 3, 4, 5 days just because of one person. One person who has not resisted, who has come to, who you agree with his lawyers, walked to your offices in the CID office, did your work. After you have released him, he's going 4, 5 cars going across his road to arrest the very person who has just left the police premises. All those things are unwarranted. All those things are mere show of force. And the experience has taught us that where it matters most, when he went to court, most of these cases, they still could not even prove his case. So it's not anything new. It's basically commonsensical. It is basically restricted to human rights issues that we have all subscribed to. I am not saying that if a person has resisted or a person is evading a lawful arrest and those things, you can't organize people to arrest him. I am not saying that if a person has misconducted within himself, within the premises, you don't have the power to tame him. But I'm saying, at what level must you go when you know that you are operating under what? Under a defined law, an act of parliament. And that act of parliament is subject to the interpretation of what? Application what? Of the courts. So my point is that the minority have done enough to draw attention to Mr. Wontumi's case. But as I indicated to you earlier on, for me, they should be able to go to court. The lawyers should be able to go to court by now to let the court know the state of affairs. Because you see, human rights is a universal concept. It's a universal principle. And it doesn't matter which government you live on. And once if you look at the UN Charter, a fundamental human right, wherever you live, you need to. But you see, accord the same principle to your opponent, because one day, just like we said, the karma thing, it will be applied to you. I have seen more human-centered national security advisors and how they have acted. I mean, under Chairman, so many things could have happened. Chairman was so nice and so gentle that he handled many of these things without even letting it come to the public. And I think this is how we have to look at the thing. Not to make it look like something odious has happened. When they went to the former governor's house, what have we heard again about that thing? Meanwhile, look at how Japa marshals some people to go there as if he's some special person we have not seen in Ghana before. You should go and find out the days of a J-Body, where a J-Body is today. A J-Body and the PNDC when Rollins came. Go and find out the name of a J-Body in PNDC affair. You should look at 1994-95. Dr. Taboson, they were activists of the MPP, of the NDC. How they treated and dealt with people. Dr. Tony Edu, today, what is their relevance in NDC? Who has done more intellectual debate to harsh people? Dr. Tony Edu said that in politics, the fairness means that you don't put your opponent on your table so that he can become taller like you. Debate, he and Jake. All manner of intellectual understanding of what the NDC is. And today, what are they? Your relevance will be appreciated if you do virtuous things. I am not saying that you cannot deal with these people. What I'm saying is that people have come and gone in different departments, trying to believe and do things as if they are more. Without them, probably the establishment will go that way. And the establishment is there. Where is Eric Honecker? The most powerful person those days in Europe is in Europe. Where is Eric Honecker? Eric Honecker had to run away from East Germany to Chile and died in a cemetery.
He died in a cemetery? He
died in a cemetery in Chile. The person he went to seek protection from, Augusto Pinochet. How did Augusto Pinochet end up when he had to come for medical treatment in UK? I am speaking of abuse of power and people who think that without them the system or the country will wither away. Exercise power according to law. Respect the law, because when you also find yourself or any of your people or relatives find themselves, you will expect that the law will respect their rights. But the question is, just like he said, do unto others what you want others to do unto you. If you go for the Mosaic law, an eye for an eye, one day all of us will be blind.
Anyway, so before I come to you, Dennis, this institution called EOCO, Economic and Organized Crime Office, it has always been there. It's established by an act of parliament. We all know they've been doing their work. They've done a lot of investigations, even recently under Tiwa Adodankwa. Several investigations were done. It appears they used to do their stuff really on the quiet. But since the coming into office of the current administration, and particularly under the current leader, Raymond Archer, it appears EOCO is going more public. They want their activities to be known more publicly. Should that be the route that they should take? Or they should probably, because of how sensitive their work is, they are investigating organized crime. So these are things that should be done without fanfare. You could have invited the person quietly, peacefully, deal with the person. If you are not able to finish, the person goes home, say, come back tomorrow. And everybody would not have heard that Wontumi was even under any form of investigation. Should that be the approach? Or the approach should be this Rambo style of doing things where it becomes public announcement and all that kind of stuff? Is that the way EOCO should be going?
You see, my brother, EOCO came from something called Serious Fraud Office.
Yes.
I remember when this bill was introduced in somewhere 1995. The concerns of Mr. J.H. Mensah and a few others. In as much as they appreciated the introduction of something to deal with economic crime. You see, when the economy is growing, all manner of things will happen. And therefore, you need a special unit of that nature. I remember the views of these people, and by 96, thereabout, particularly J.H. Mensah and Mr. S.K. Boafo, They were the people who really spoke to it. In as much as they were supported the bill, they had some caution that if you confer powers of this nature into the hands of private government-appointed people, there must be concern because they are likely to abuse it. But I remember those days, the Speaker then, Justice Anna, who would then bring all these things together so that the Constitution has conferred fundamental rights, of which if your rights are violated in any of these, by any of these institutions, you can't seek justice. So this debate went on before it came, and then subsequently it was transformed to Yoko.
I think it was in 2010 that it was transformed into Yoko by an act of parliament. Yes, 2010.
I remember very well. I think that time it was Madam Idrisu who was the Attorney General. And they were doing similar things and people were complaining. But he said anti-graft agencies must be robust and strong and should be able to deter people from committing crimes. In the case as we find it, ordinarily if the organization wants the public to develop interest in its activities and to know what it is doing, that is why organizations have PR departments and to issue statements. It is not for them to create scenes of people who are not even suspects. As we speak, Wontumi is not a suspect. They are not even suspects. They are people you have invited to say assist us in investigation, or we are investigating you over A, B, C, D, and therefore want to hear your side.
But you know, when you said Wontumi is not a suspect, then it drew my attention to the statement that was issued by Srimsai. Srimsai is the Deputy Attorney General. Mm-hmm. When this whole arrest issue has started happening, he went on his Twitter handle to make a post. And this was the post that he said there. Suspect Bernard Enchibuesiako, aka Chairman Wontumi, is under investigation for various criminal offences, including fraud, causing financial loss to the state, and money laundering. The criminal investigations is running concurrently with asset recovery processes to prevent further dissipation of what law enforcement agencies strongly suspect to be proceeds of crime. The suspect is also under a second strand of investigation, which is part of a larger international organized crime scheme. The Economic and Organized Crime Office, YOCO, is assiduously working with our international law enforcement partners on this second strand of criminal investigations. This is a statement issued by Srimsai on his Twitter handle.
It is neither here nor there. All the things he says are what? Allegations. And all the things they suspect that the man has done are also allegations. Have you heard the side of Wontumi? If a person has not been heard, will this is purely evidence in chief. It's a narration of what he intends to put in his witness statement one day. And it will be subjected to straight proof. The question is that in all these, does the Lord grant you exceptional powers to violate the person's right? He has a right to legal counsel. He has a right to all the fair hearings at the administrative level you are required to. And we are saying that, do you need to put these things there to make it look like the heavens are coming down? So my concern is not about the fact that if somebody had done wrong and is being investigated, it should not. My concern is whether the law has been respected, because as a lawyer, that is my job. And it can happen to any of us here in this republic. Your rights can be trampled upon easily by administrative officers. And we have seen situations. What didn't Kojun Pinim and Roku Bibi go through in Ghana? In the end, what happened at the court? The Yana Ameda trial. What didn't people say? From the rooftop. Then they say, oh, and they say friends. And then what? What happened? So I'm saying that we give you these institutions to head because of the training and how meticulous we expect you to be. You see, if you are in power, you can be taken by the strength of power and the position you occupy as if you are above the law. And that is why, because I'm the constitutional government, we have the way to apply the brakes to let your senses come down so that you don't deal with people on grounds of suspicions and passions. But you will deal with people on grounds of the facts as before you. Many things states have alleged that went to court could not be proved. Many things officers have alleged and made statements on the rooftop. When these things went to court, for the proper thing to be done, because that is the forum we have accepted to settle disputes, people would improve their case. And but you do as I said, 18 cases against MPP persons. Nothing. He got nothing. Ghana 50 is one of them. Read the Ghana 50 judgment. That is Mafuzam. And you will see how administrative powers, administrative organizations should actually what? Behave and conduct their businesses. If the act confer powers on you as a director of NIB or police ID or YOKO, it does not confer beyond what the law says. You exercise a discretion, and the discretion must be guided. I am not, as I keep on repeating myself, Wontumi must be dealt with according to law. That is all that we seek. Because Sednam Tamaklo was dealt with according to law. He has been convicted, and you have allowed her to run away. I have always been, and I think one day when I told the general who the press conference, I was there and asked him what effort is he going to make to bring that lady to come and face justice. Okay, but at least for her, she's a convicted person. These are mere suspects. You don't leave a convicted person to go and stay somewhere to enjoy the booty, the money for poor people.
But the funny thing is that she left the jurisdiction under the watch of the MPP. So she was standing trial.
Yes.
She went to the court and told the court that she had to go for some medical.
Because we respected the law.
And
respected his human rights.
And because of her fundamental human rights and right to health,
yes,
the court, based on those grounds, released her passport to her.
Yes.
And then she traveled.
Yes.
And then subsequently never returned.
Yes.
Yes.
So when we want to reset and create the impression that we wrongly allow her to go, it is also fair that you also rightly bring her home.
Okay. So that is something that you would want to see the current government do.
Because that is how we can get our money. We are interested. How much was involved? 95 million Ghana cedis.
There was several.
And
I've forgotten the exact amount.
Do you know what that money can do to your village and my village?
Some of the monies were received at allegedly. Okay, that is not alleged. It's
Yes.
been proven in court.
Yes.
So they were received at Bachona.
Yeah, fully station.
So she issued a check in the name of Maslock to a borrower. The borrower said that the interest was too high, and so was returning the check. Then she says, "Don't return check, return cash." And then the person went to the bank, cashed the money in a Ghana must go bag, and brought it to her at Bachona filling station. At least that is the narration that we saw, and put it in her boot. Okay, all right, Dennis. So I'll cut to you, but just before I get your last thoughts on this Wontumi issue, with my question. Kweku Ohiming is in Scotland, Aberdeen, and he's one of our regular listeners. He's sent a message. Let me just read it quickly before we move on. Okay, so Kwesi Ohiming says that, "Good morning, Wilberforce. What is happening in Ghana regarding Wontumi is deeply troubling and should concern us all. The 50 million Ghana cedi bill imposed is excessive and disproportionate. Justice must never be used as a political weapon. Tell Dennis, the NDC lawyer, that in 2012 it was NDC government that granted Alfred Woyomi bail despite the scale of his case, and even reduced the amount to 20 million Ghana cedis. Attempt to override or politicize due process now sets a dangerous precedent. We must rise and speak out before public trust in our legal system is completely eroded." From Kweku Ohiming in Scotland, in Aberdeen. Kweku, thank you for your message as always. There is Ofusuba who says that, "Your listeners are very seriously absorbing accurate information and facts. We don't need sarcastic and ambiguous opinions and irrelevant information to deter our readiness for vital issues, not political rhetoric." Okay, so hard language, but I understand you, Ofosuba. All right, a last message before I come to you, Dennis. Wilberforce, anytime I see the happenings in the question I asked myself, is, can't we just adopt best practices, civility and responsibility wherever we are confronted with issues? These are hallmark of a great leader. I remember very well when Nana Addo Dankwa Akufo-Addo was asked why he didn't prosecute the double salary culprits, he said that the political atmosphere was not conducive for that. I understand it hurt MPP members, but for me, I see one great leader who has attributes of responsibility, civility, and best practices. Posterity will make him one of the best leaders the country ever had, and that is Asante Isaac. All right, so Dennis, the request on the streets is that the NDC government current should revise its approach to dealing with its political opponents when it comes to wrongdoing. It looks like they made promises to their followers, and because of those promises, they must be seen doing something to show the followers that, yes, we said there was corruption. Now this is the corruption. But that obviously will go against the rule of law. And so the NDC should be revising these notes, deal with people according to the rule of law, even if you find them to have involved themselves in wrongdoing. Is that something you would subscribe to? Or the model that is being used now, arrest them, detain them, keep them beyond 48 hours, grant them bail. If they are not able to meet the bail, it is their problem. It's not our problem.
Wilberforce, I'm enjoying the mischief. And
mischief from him?
You.
I'm
I'm a senior, so
yeah.
I'm enjoying.
I'm only asking a question.
I'm enjoying.
You are enjoying the question.
No,
okay. I'm glad you are enjoying the question.
Mischief is the
I'm enjoying.
Is that the address here? I don't know.
I'm enjoying.
I'm sure he's enjoying real stuff and facts and historical
yes.
facts. Yes. I'm saying, relax. I'm sure. No.
Relax. You see, it depends on which side of the street you are coming from, and what you decided to listen to. But I'm saying that, you see, when it comes to this issue of Wontumi and the fact that he's been granted bail, he's not able to meet the bail bond and all that, it is not about Wontumi as a person or NDC as a political party. It's about Ghana and how we have structured the way our things should be done. Now we are talking about the 48-hour rule. Mm-hmm. Senior knows that when it comes to the 48-hour rules, the police have a way of dealing with the 48-hour rules such that
they undermine it. Have you read the Supreme Court decision on it? Have you read that decision? The 48 hours is 48 hours.
Yes, wait. 48 hours is 48 hours. Yes. But they have a way of dealing with it in such a way that at any point in time, it truncates and restarts.
How do they do that?
We'll get there. At any point in time, it truncates and restarts. And so we will not want to say they are wrong until we get to court. And then they will tell the court how they calculated their 48 hours, where they got to, where it truncated, where it restarted, and where we are. You see, in all this, I don't think that Wontumi has not been treated fairly. In fact, he's been treated fairly. He's been given all the opportunities. But when Senior says that...
What are some of the opportunities you think he's been given?
Oh, but when he complained about his health, he was taken to the hospital. I hear he's been offered the best of foods. He says, I'm reading somewhere that he says he's on hunger. I'm saying that I've heard that he says he's on hunger strike or of a sort.
His lawyer has denied that.
Okay.
But he has not been taken to court, which is the most important.
Oh, no.
Once his liberties have been taken, you're a lawyer, so once his liberties have been taken, yes.
I'm saying that his lawyer has always been with him. So if he has any problem with the way he's being handled, or he smells or senses any breach of any law, he knows what to do. Indeed, he's our senior. And so he understands what is going on. And so we can't just sit here and conjecture that, everything is wrong. But the man has not been denied anything. He's not been denied anything. Everything is moving as it should. And that has been the way anybody who has been suspected of doing any wrong has been treated. Even to me, wouldn't change. But I find it troubling when senior says you are going to arrest. What word did you use? Just a simple man.
A mosquito.
He used mosquito. The man is not even a cockroach, let alone a mosquito. Someone who can just shout and the place will be filled with people. You expect just one policeman to go there
against the whole
someone wait. Oh, senior, you are the one who said
okay.
Someone who can just create the impression that the whole state is coming after him and let people mass up. You will expect just one policeman to go and invite him or arrest him. Someone who says that the current president, when he was president some time past, had to ask permission from him before entering his territory or his region because he's a governor. Someone when the man says he's a governor, and even the security services will have to come and negotiate with him before he allows the current president. When he was...
Is that not political talk?
And so every political talk attracts a political action. So why? A political reaction. So what is the problem? There's no problem anywhere. Things are happening. You see, when you use a political talk to create an army, you should expect that when another president is passing where you are, he will also come with his army. Nobody should take... You see, words are so powerful. So when council tells me that anywhere you meet me, prepare. You think when I'm sensing him, I'll not prepare? I'll prepare.
Your senior counsel.
Yes. How will I come to you? How will I come?
Or would you know I will not make such a statement?
No, I'm saying that. And preparation may mean anything.
I see.
If you are talking about prepare physically, it's different. If you say prepare legally, it's also different.
Prepare spiritually too.
I don't understand that one. And so anytime I'm meeting you, I have to prepare. So when the person says he's a governor and he has an army and he has people who are so strong that the state will have to ask permission from him before entering the region, you don't take these words for granted and send one policeman to go and invite him. And you see, these things have been demonstrated, as I said earlier on. They've been demonstrated. And so don't let us see IOCO as a wicked institution. They're only doing their work. And when senior says that, the one you spoke to on phone, that in granting bail, we should check whether he's a flight risk, he has... well, we understand that all those elements will count. But the other question that should be answered is that when you release the man on bail, is he able or capable of committing another offense? That is what we should be thinking about. That when he comes out, what is he likely to do?
And that should form the basis before the person is granted bail?
By administrative officer.
You see, it is part of the requirements of every bail condition.
So put him before court.
It is part. You see, senior, these institutions and their workings, you know that it is not all that we will know. It is not all that we will know.
So put him before
at the end of the day,
so put him before court.
But
the law says go to court.
But the law says go to court. Is it every court proceedings that you are
have you been to court to see
is it every court proceeding that you are privy to? Don't certain things even happen in camera. There are certain things going on that you may not even be aware of. I say he has a senior counsel working for him. So if things are not being done well, you put them out. Even if you will not put them out, you will address them. So it is not for us to sit here and conjecture that once MPP is not in power, anything that state institutions are doing against an NDC suspect and an MPP suspect is wrong.
So don't you? Well, I think that what I hear Mr. Jemfi suggesting is that so you invite Wontumi, he comes. You are doing an investigation. Let's say you are not able to complete the investigations within 48 hours. The rules are that you, as the arresting authority, can go to court, even if it is not on notice, to go and tell the court that, oh my lord, we are investigating this person. He's a subject of interest. We have not been able to complete it within 48 hours. Can you give us a court order to keep him for another 7 days so that we can continue with the investigation? The court issues an order to detain him or to keep him in your custody. In the Dubois case,
exactly,
you went to court one day and said that he was interfering with witnesses. So the court should allow you to keep him for 7 working days. And the court agreed and gave him to you for 7 working days. You kept him and did all that you had to do. And then after the 7 working days, you came back to court, and the court now reinstated his bail, and then he went home. Even that he didn't even go home the same day. They still kept him for another 3-4 days before he was finally allowed to go home. So I think what he's suggesting is that in the name of the rule of law, just do the right thing. What stopped Iyoko after 48 hours? Even if you granted a man bail and he couldn't meet the bail condition, after the 48 hours, go to court and tell the court that we granted him bail this amount. We are doing an investigation. We haven't finished. We still need him. So court, permit us to keep him for another 1 week. And the court grants it. If the court doesn't grant it, you even have the opportunity to even appeal. No. So all he's just saying is that go through the right process.
If I would put in something small,
it is even in my initial statement or the statement I made before this commentary that are you able to tell whether this has been done or not?
If Iyoko has gone to the court, we will know.
Why wouldn't we know? So he goes
I'm saying that if it has not been done, you know the remedy.
Do you know something, my brother? From the practice with the police, and I've done 6 cases at the police headquarters, what they would do, which is normal and we have witnessed it across the country, is that they will charge you provisionally, and then we go to court. Then bail will be done. Then they come back after they've completed their work. Then they will come and withdraw the provisional charge or the earlier charge they give you and file a fresh charge sheet. In this case, let me grant the Iyoko the fact that based on the things that Justice Simpson wrote, they are doing so many things. This 48-hour rule is a constitutional requirement.
Article 14,
yes.
Clause 2, subclause 4.
Yes.
It says that where a person arrested, restricted, or detained under paragraph A or B of clause 3 of this article is not tried within a reasonable time, then without prejudice to any further proceedings that may be brought against him, he shall be released, either unconditionally or upon reasonable conditions, including in particular conditions reasonably necessary to ensure that he appears at a later date for trial or for proceedings preliminary to the trial. Okay, so I think I missed the 48. The 48 one is rather clause 2 B. So he says that upon reasonable suspicion of him committed or being about to commit a crime, offense under the laws of Ghana, and who is not released, shall be brought before a court within 48 hours after the arrest, restriction, or detention. And so this is Article 14, Clause 2. So Article 14, Clause 3B. Yes.
You see, under 1979 Constitution, it was 24 hours. I think 69, it was 24 hours. Then the Consultative Assembly considered all the experience from independence and the 1992 Constitution. The discussion was that given the handicaps the state institutions go through in obtaining information, the 24-hour rule was unfair to the state. and that the state may sometimes be in such a condition. The opposing side was that we are not stopping you from investigating the person. What we are saying is that for us to be sure of the safety of the accused persons too, because the accused person, once there's a suspect or whatever is accused person, he's not been convicted. So it shouldn't be made to look like the person's right might be completely curtailed as if it's a convicted criminal. So the whole discussion was, okay, then it can be extended so that it's because of the lack of infrastructure for the police, CID, and the institution to work. That is how the 48 hour, yes, came. So my case is very, very simple, which we all practice every day in the courts. When you cannot meet the requirements of the 48 because of the nature of the investigation and whatever you are doing, just go to court. I said, my Lord, yes, this is the law. We were unable, A, B, C, D. These are the reasons. The court will look at how plausible your argument is and will definitely extend it. So the person will then be in lawful custody. In this case, as we have seen it, the person is not in lawful custody because the 48 hour has been broken. We don't have any evidence to show that the parties have gone to court and that the other side, Wontumi's lawyers, were there. Because you see, a person arrested is entitled to legal counsel. He must know what is going on. So this is not a matter you can do even ex parte. You have to do it on.
In fact, if they had gone to court, then why would the time for them? Why would if the Iyoko had gone to court, then there would be no need for Wontumi's lawyers to go to court.
Yes.
Because if they were going to court, then it means that maybe the court had given an order that they want to either review or revise and all that kind of stuff. But now they have gone to court ahead of Iyoko.
See, the seriousness of the matter is that, you see,
what are they seeking the court to
with due respect, my brother,
for them?
They are asking the court to vary the bail condition that has been given to Wontumi.
You see, the point is that when you come up against the Republic, it's not a small matter. He said that Wontumi is big. Wontumi is big in terms of human nature, material.
In terms of the way he has portrayed himself.
Because he's the original chairman.
No,
of
he
the MPP
he says he's a governor.
I'm saying that is political talk.
No, and
is he a governor?
It is that. Wait.
Is he a governor?
It is that political talk that has brought us where we are. You see, and actions after that.
You are feeding into a stupid. And feeding into it. The question is that, my brother. The question is that, I mean, a whole Republic of Ghana that you have come up against 31 million people, the machinery available to the state, the National Investigation Bureau, the CID, military, directly intelligence, police professional, all the institutions of intelligence are at you, one person. So the presumption is that the person is what? Is innocent, because to come up against these structures is not an easy experience. My brother probably has not experienced them before. What it is to come within such powers.
To be the guest of
For
the
me,
state.
my practice in BNI and tax intelligence and those things, I have seen where real power is. I'm one of those who have done several cases in hearing in BNI cells. And I can tell you, it is not an easy experience. That is why the presumption is that deal with the person, but within 48 hours. Those days, if you say we have been invited to BNI cells interrogation room, but you see, we have considered all the iniquities we have gone through since 1957. The things that happened under the PDA, the powers conferred on the state, which was so enormous that it was abused to the extent that even party members, even Bedema had to run away. Bedema, who brought Nkrumah, had to run away. The protective custody law and the Abuzia set powers conferred on people. Certain things to the extent that even the Minister for Information and the NLC Abuzia had to resign. If I remember the name, KG Osebunzu, there was some disagreements. Protective custody law. Go and find out the number of people who were detained and such opportunity was not given to them, to the government. Read about the confidence of Nkrumah and those things. Even Commission of Inquiries. Read this case, Otu and Attorney General decided by Acha, where commission had been established and people even made prejudicial comments and they went to court and they got their freedom. When we come to a Champon and all the party of Usuama and all those things and the problems and the death of the richest brother Ambrose, find out what the state did to the Ghanaians. So we are saying that with this experience, 48 hours, let's respect it. Go to court, get an order, lawfully detain the person. The so-called investigation, all the things alleged by same side, it could be completed. You can't complete everything if you think that is not enough. You start the process somewhere, and then the law will take its course. Master, it is about human rights. Once you come against the state, you know that even where a person is not represented, there is an authority that says that the court must not necessarily come to the arena of conflict, but must be careful and cautious with the way the suspect will be treated. We know all these. We've practiced this in court since we became lawyers. We have read these things from our history books and social studies and government books, those of us who were government teachers. So why do we continue to repeat it? And to try to do a showman's job as if the law doesn't matter, but once I have overwhelming majority. You see, these are the mistakes you make. That makes the opposition easier for opposition to reorganize. He made allegations that people were giving money to come. I mean, can you suspend say that? That people said they were that what people say is what you work with as a lawyer.
No, we are not in court. Please, we are not in court.
But you know,
and I'm not taking. Listen, I've not taken this to court as my evidence. I'm saying that it is on radio, on social media, that someone says they ask someone, "Why are you here?" He said, "I came here yesterday. I got 1,300." And so I've come today. I know today.
What if I suggest that
let me
pay
finish.
the person to come and tell?
Let me finish. No, let me finish. Then there's another video where two persons are captured. By me, I'm not a media man. So it's if you are saying that if I see something like that on your channel, it's fake news or it is a skit. Fine. Where some 2 or 3 persons are sharing money from what they got from what they want to do, and I'm making reference to it. It doesn't mean that as a lawyer I cannot make reference to things I've seen on video or something.
Okay.
Why do you make it look like
the question is my conclusion, my brother?
Yes.
We have seen and practiced the law. He says we are all old. It's true, we are all old. We have witnessed things. And this, for me, is enough. It's unwarranted. The greatest of respect.
Okay.
It's unwarranted.
You know, the interesting thing is that even when you go to court and the court grants bail, usually I hear the court attaching, you are to report to the police Mondays and Tuesdays and Wednesdays and all those kind of things, because even with that, it allows the investigations to continue. So I remember when Edu Boahin was granted bail, he was to report Monday, Wednesdays, and Fridays. And so Monday, Wednesdays, and Fridays, he goes and reports, and then whatever investigations that you are doing, you can continue doing them. So just merely keeping the person without respecting the 48-hour rules, really, if you look at it carefully, probably doesn't make sense.
That and I'm saying that, you see.
And let me just announce that Oxford Osei-Bonsu is joining us via Zoom, and I'm going to come to you. We are going to talk about the Chief Justice issues, and so we are going to start with Oxford on the Chief Justice matter. Yes, so this is the last comment on this subject.
For everything that happens to an individual that seeks to catch the rights of the person, there's a remedy. And so this back and forth about what has been done right, what has been done wrong. If the state is supposed to go to court within 48 hours or go to court within 48 hours or release you unconditionally or conditionally, and they have failed to do so, as counsel, we know what to do. So the lawyers
you didn't hear the lawyer Kwame Adofo.
The lawyers should take action.
You didn't hear Kwame Adofo.
Okay, all right. So Oxford, thank you very much for joining us via Zoom this morning and to share your thoughts with us. Just before I come to you, Haruna says that good morning to you all. In fact, President Mahama is behind Chairman Wontumi's issue. Everybody in this country knows that guy give birth to NDC. That is why their arrogance of power is too high. But they ought to know that tomorrow is pregnant when the table turns they will hear from us. Okay, that's Haruna Al Hassan. I don't know who he is, and then the power with which he's speaking.
And that is part of the reasons why what they think is wrong cannot be turned right.
Okay.
We've received too many threats.
Okay. So there's somebody who has changed my name from Wilberforce to Oberforce. Oh no, this is Overforce. Okay, so he decided to give me a new name, Overforce. I am listening and enjoying the show. Are we expected to deposit the amount bail bond in hard cash? Oh, okay, Charles, please. In terms of bail, you don't carry the 50 million Ghana cedis in a bag and go and put it there. The bail is not as in physical cash, but it's just saying that in the event that the person you are standing bail for vanishes or runs away, that person who is standing surety, if he has a property, whether that property will be sold to replace the money. So you don't carry the money when you are being granted bail. You don't do that. Okay, so I hope that clarifies the matter. And so Asante says that Wilberforce, what is happening to Chairman Wontumi is purely political. Nothing will come out of it. It's just to please the NDC base. Is that so? Okay, so that is Asante Isaac's message. And last message before I come to Oxford, he says that Wilberforce, I think my party MPP will learn a big lesson from what is going on in the country right now. We did not prosecute the double salary culprits. Atuforsen ambulance case. A former senior minister and MP led Atuforsen to Godfrey Damin's house to plead on his behalf. Lessons must be learned from this because time doesn't have enough. There's not enough time to give us time, so we must do everything accordingly while we have time. Okay, so this is more philosophical than I thought. All right, so Oxford, your quick thoughts on Wontumi. We are told that Wontumi's rights are being abused by supporters of the MPP. The NDC saying that Wontumi's rights have been respected through and through. What do you make of that? And then we'll talk about the CJ. The CJ is saying that her rights is being trampled upon. She says that you say you have established a prima facie case against me, but you have not given me anything to prove that you have established a prima facie case against me. So give it to me, and then we can start from there. But if you just say you have established prima facie case against me by word of mouth, that is not judicial. That is not the way to go. Oxford, we are in your hands.
All right, thank you very much. First of all, let me say good morning to my seniors in the studio, and then good morning to our great listeners. In fact, it's very interesting where we have gotten to. And as we are having the argument in studio, on the streets, there's only one person who is suffering, Chairman Wontumi. So my quest is that, first of all, there have been enough evidence by, if you take it, we presume that NDC as a political party or NDC as a political party is using state institutions to persecute MPP. That is a presumption. I'm not saying that. That is the presumption on the street. If we have presumed that, what are you supposed to do as lawyers for Wontumi, as lawyers belonging to the MPP political party? You have to see any institution now as an adversary, somebody who will hit you or hurt you so much. So even from day one, when Wontumi was given indication that you'll be arrested, we should have been preparing all the options available in legal terms. So whether a bail will be given and will be onerous, what are the steps that we are supposed to take? What are the other remedies? Of course, unfortunate thing is that the Constitution has laid down a procedure for arrest. At 30 also had done the same thing. Now, the Constitution is supreme and then surpasses whatever provision is in the Act. You have to bear in mind that YOCO as an institution, whether it's satisfying the state or satisfying a political party, will need to come out with taxes. Taxes that will enable them to conduct even a procedure that will hurt you before even the court or whatever forum, pronounce you innocent. So forget about what they are doing, whether they are keeping Wontumi for 48 hours. If it is a constitution that YOCO is breaching, what are the remedy, even in the constitution, available to the lawyers of Wontumi. We have prerogative rights. They can issue. We are here. I think they arrested him other Tuesday or Wednesday. We are tossing, moving up and down. We have even accepted that there are some charges or charges against Wontumi, or although they've not given it, we will have to answer those charges, whether we like it or not. So by now, we should have gone to court, not just to vary the condition of the bill, but even ask that Yoko produce Wontumi to the court, for the court to ascertain whether the detention is lawful or unlawful. It is not within our remit to be discussing whether the detention is lawful or unlawful. We know, but then it's only the court who can actually pronounce it. So I believe if we are too late in time, that's the only thing I would say. We should prepare. I mean, I'm not, when I say we should prepare, I'm saying that if anybody believes that an action that's an institution, probably might exercise that could hurt them, they should prepare to also face the same thing. The only remedy for us is to go to court. I believe at this point is to go to court, because Wontumi is a NPP Asante Regional Chairman. So it is not out of place for minority or even party members to actually assemble before Yoko. I mean, they want their party chairman, so it's not wrong. And even when they were there, Honorable Afenima can make it clearly that, yes, of course, we are not saying that, allow Wontumi to go. If you believe we suspect him of any crime, follow the procedure. So to Honorable Afenima, he also believed that it's the bill which is too high that is keeping Wontumi in their custody. And so we have two options, as I'm saying. Let's go to court under the Constitution, or we can go to court under the Act to also vary the condition, bail terms, if that is what we want to do. But me, I would have go under the option of habeas corpus, and then we get Wontumi before court. And probably the court will allow Wontumi to go home. That's my thought.
Okay, all right. So great. So let's switch over to the Chief Justice issue. The Chief Justice is saying that her rights are being abused. She goes to the Supreme Court, her own court, the CJ's court. The judges threw her out, and all that. Matters arising. This committee sitting is going to continue in its current form, which some people are referring to as quote-unquote kangaroo, because it is not doing things the right way. What do you make of this position and this request by the CJ saying that, give me the prima facie you have established against me so I can answer? The people say they won't do it. The committee is calling witnesses. The main people who are accusing are not giving any testimony. The whole thing, according to the Chief Justice, is bizarre. Is it bizarre to you as well, say? Oxford.
It's very unfortunate, Chief Justice. She's still, under suspension, but she's our Chief Justice. And thinking about her being a woman, and the last time she appeared before the court, we also, some videos, and it's very, very unfortunate that she's going through this situation. We only envisage or dream, imagine what she's actually going through. But first of all, I have to understand whether the request was made to the committee, that the committee refused to provide the prima facie, case, or the actual reason for the committee work. I think the lawyers are supposed to do, again, the lawyers of Chief Justice are supposed to do a very good work and try as much as possible to engage. I'm saying so is that because the Supreme Court has demonstrated to us, not one, not twice, but 3 times, that they might not injunct the process. They will allow the constitutional process to prevail. Of course, we mentioned another constitutional relief that we have. So If they believe that at this point the committee has to work, so be. So I think probably when we go into the substantive matters, we will understand certain things, or certain things will come up. But we cannot subject the Chief Justice to that terrifying situation. So I believe instead of us or the lawyers coming to the public or to the court, they should find a way of engaging. Like we said, the members, 2 of them are actually the colleagues of the Chief Justice herself. She worked with them. So we cannot do that. In matters of human rights, it's the person that suffers. We can make all the conversation around the person, but it's the person that suffers. So that is my first point, because I said that the way the matter, started, right from Chief Justice asking for a copy of the petition that was sent to the president, it changes the dynamics. It changes so many things. So we might wait for the process to, prevail to a point whereby, if truly by the conclusion of the committee work, we find some of the findings of the procedure then not being, following the provisions of the Constitution, then we can come to court for another remedy. But now, as we are here, whether we like it or not, I think that's the condition, that the situation we find ourselves now. Whether we like it or not, the Chief Justice will face the situation. And then at the end of the day, we'll now wait to see what the conclusion will be for the committee. And then again, we still have 3 matters before the court to also decide on. So we will see what will also be the outcome of the decision of the court. At the end of the day, whatever experience we gather here is just for us to, improve the situation in the future. So that is my feeling. I feel so bad. I feel so bad about the situation of the Chief Justice. It's very unfortunate. It's very, very unfortunate. And that is what happens. Sometimes you have a good case, but depending on the procedure, or you might also have a good case depending on whoever is on your side to handle the matter on your behalf. So I believe we have to have some cool heads when it comes to these matters. We should sit down and then approach it differently. Politics is politics and law is the law. But there's a blend, and the fact that party changes, or maybe we change government, obviously, whether you had committed something or not, you expect that we'll push you a little bit. So we should be in readiness and think that if the new political party is in power, the one that left power should also be in readiness to see how they will subject them to accountability. Whether you like it or not, see this process as an accountability process to the government, to the state, and to the state institutions.
Okay.
Thank you.
All right. So, interesting thoughts there. Let me come to the studio. Stay with us, Oxford. Okay. I'll come back to you, but let me come to the studio, and I will come to Mr. Jemfi, then I'll come to Dennis. If you look, I've seen a message from Ohime Boachi, who is our friend in Scotland. He says that as Wilberforce, it's truly sad to witness judges treating one of their own, someone simply trying to fight for her freedom in her capacity as Chief Justice, in such a harsh and unfair manner. This does not reflect the spirit of justice and equality before the law. Rather, it appears more like political persecution than a fair legal process. I have always seen the Chief Justice as a strong, principled woman who has dedicated her life to upholding the rule of law. That she now finds herself seemingly targeted raises serious questions about the independence and integrity of our judiciary. If one of the highest ranking judicial officers can be treated in this way, what hope is there for the ordinary citizen? The attitude is deeply troubling and makes many of us feel that the judiciary is increasingly leaning towards political influence rather than standing firm as a neutral and independent institution. Justice must be impartial and consistent, free from political undercurrents and partisan interest. We must all raise our voices and insist on a judiciary that serves the people, not political agendas. A compromised justice system threatens democracy itself. And that is Kweku's message. Okay, so Mr. Gyamfi, I see you nodding your head to Kweku's comments over there. You seem, all through our interaction today, you seem to be troubled with the processes going on at the Supreme Court and at the committee level. Oh, sorry. Your microphone was down. Please, yes.
Yes, to a large extent. You see, my brother, if the president had not made comment to the effect that this is what they would do, ordinarily nobody would have had problems that we have today with the whole exercise. Our friend here said that he worked under Dr. Kwamneji. You remember the infamous case of Dr. Kwamneji? Several ways to kill what? A cat. I'm sure he recalls that statement he made. You do very well. That's very good of you. That's very good of you.
He seems to be a student of
Dr. Kwamneji.
Dr. Kwamneji, yes.
You can kill a cat by slaughtering it by cutting the neck. It's a very, very precarious job to do. You can kill a cat by.
He did not elaborate. So
I'm
say that the elaboration is yours.
It's mine. It's mine. But he has indicated that there are various options.
No, he was only stating a fact.
You can kill a cat by various ways. So many ways of killing a cat.
Which is a fact.
Which is true.
Yeah.
Before the election, the National Communication Officer said that security officers are making their tenure of office coterminous with that of Nana Akufo-Addo, and that they should know that the way the next day government changes their office. You remember the statement? I'm paraphrasing.
It looks like all of them have been
very well
gone on retirement.
So why wouldn't the Chief Justice be cautious? We have retired probably first time in our history 4 3-star generals. Quality generals, some of them, we know, we have interacted with them. They are home now for political reasons. You will recall the statement when they met the NDC lawyers, how they should prepare themselves also to come, and how it has become, for now, we don't know how the road will look like. So the intentions and the idea to get the Chief Justice out is a political statement the president made, and he's pursuing it. Now the question is, will any lawyer just accept the defeat and go back? It is not part of our training. Professor Kumado will tell you, even where you are wrong, go to the last point of it. It doesn't mean that you can't concede or you can't be flexible at a certain point, but at least you know that your journey has not ended. We have sat in this studio where Nipapo has advised that, why would the Chief Justice just forget about all these things and take her entitlement and resign and leave the place? You set up a repression of this nature against me in a political vow, and you want to advise me to accept the repression, something that is not the DNA of a lawyer, to go back home so that you achieve your political goals. That will never happen. But what is going on in the Supreme Court is troubling. I must be very, very frank. Because if you are doing human rights cases in courts now, and these things are going to be factoring in your possible judgment, because I have 2 cases in which some of the things we are doing, because if a prima facie has been established against me, it means some level of inquiry has been done into the allegations against me. That ought to be gone into properly. And I will not be able to have a copy and say that this inquiry or this opinion you form about me is in a report and I, the subject person, cannot get a copy. It is the first time I'm reading and hearing this. We respect our brothers and seniors at the Supreme Court. We respect the officers. But you see, the law is a learning process. Professor Kumado will tell you that every day we learn. New things come. And even things that have been there as status quo can be challenged. That is why Supreme Court is not bound by its previous decision. It can change its mind today if there is a need to change it by persuasive argument. Meanwhile, it is clear in administrative law. Because that decision by the committee is an administrative decision. Administrative bodies and people exercising administrative powers shall be fair. And a person aggrieved by such decisions shall have the right to go to court. So if you form an opinion against me on the basis of an inquiry, and I have issues with it, you see, this particular committee working, I don't know the rules of engagement. Maybe the lawyers in there know what rules of engagement.
So we are told from the grapevine that the committee at its first sitting decided to operate by CI 47.
So then, the CI 47 is not operated in isolation. It's operated in relation to what? To the Constitution, because it's created by what? A constitutional instrument. I think 157 or so.
Yes, and CI 47, for the avoidance of doubt, is the High Court Civil Procedure Rules.
Yes. So if that is the basis, then you can also make certain applications pursuant to the Constitution. And it's a human rights matter. So we are yet to read the reasons that the Supreme Court gave. But just like they gave in the earlier case, and you saw the two justices dissenting in the argument made by the justices, particularly the former fantastic. Then you need to rethink about what the Supreme Court is doing, because it has grave impact on cases that are pending before the court and the teaching of the law. That if you make a prima facie against me, and I say, okay, may I have a copy? So the prima facie was made by what? By mere intuition, or by mere saying that I concur.
We understand it was done by vote. Council of State voted, and it was 30 against 1.
I agree. So wasn't anything put down? The reasons why 31 was achieved.
And for example, Abdul Basit Mahama is asking a question here, and I find it very relevant. He says that multiple petitions have been filed, yet the Chief Justice doesn't even know whether all or just some of them form the basis of the case she's being asked to answer. The logic of Supreme Court panel is difficult to understand.
In fact, I'm just being cautious and diplomatic because I'm a lawyer. But I have to hold my fire and wait for the reasons. Because at least for the little that has come there, maybe for professional reasons, I may have to be very careful so that when it comes and we read, because the same thing with the 3-2 decision. And when you read, you will see that there are lapses completely wrong. You can completely rubbish the decision of the majority that is completely not backed by law. So the same thing here. And I've been wondering what Supreme Court we have. But sometimes, you see, once you have to uphold the law, it is the court you go. And I can imagine how long this fight would be like. And I also display the argument by our friends who say, oh, it is affecting the judiciary and therefore the Chief Justice must give up. Why wouldn't the government also be advised to give up? Now the petitions that have been filed that the Chief Justice is not privy to are all lined up. When people realize the lapses in the petitions, the current petition, when the lapses. So I think that the Chief Justice should be prayed for. Yes, he should get more the courage and to fight. At this stage, we can only support her spiritually, morally, in every way, and also to ensure that the law is upheld. You see, my brother, public service, particularly when we are subject to, and it is also telling us lapses in the Constitution. Article 146 is the weakest you can talk about in all the, and if you deal with it in relation to the other arms of government. How difficult it is to remove a speaker, how difficult it is to remove a president, but how easy it is to remove a Chief Justice. Not an ordinary judge, the Chief Justice of the Republic, the most senior.
Henrietta Mensah Bonsu, her ladyship says that it is made as easy as removing the class prefect.
It is. And you can't, well, anyway, but the question is that, my brother, my point is clear. My point is clear. Let's wait for the reasons to come. But from where I sit, my doubt is still there. But we are just waiting for the reasons to come.
Okay.
And for professional reasons, we have to limit ourselves.
So
but you can see clearly, political machinery has been set up. Okay. And that political machinery. You see, it happened to Justice Waku. I think 96 or thereabout. Is it Justice Waku or Justice Adade? There was something about Justice Adade's age. At that time, the NDC was losing cases. They sponsored one gentleman, Biapalu. And I can tell you, Justice Adade, one of the finest lawyers in Ghana. He did the Salaki, the jurisprudence day. He was removed from the Supreme Court. There was a similar problem with Justice I.N.K. Waku. I don't know whether he resigned or he left or the process ditched him out. So watch these NDC people. They are machinations because they are the ones who can kill a judge. Oh yeah, that's your tradition. They are the ones who can kill a judge. Haven't we suffered from Apollo 568, the UP tradition? Haven't we suffered from it? That we send Nigerians and foreigners home when we know that they were facing civil wars at home. Haven't we suffered of it? So if you suffer from the fact that it's not on record that your people murdered, your members of your government, your founding fathers murdered the 3 justices and Mejo Akwa, is it not a fact? Didn't it come to national reconciliation for us to hear all the things that happened? What happened under Justice Akins? Don't we know that Justice Akins, the Attorney General, and the investigation, the SIB report, if you have no rest of, I can give you some. And these are the people, if they can kill you, now they can't kill you. So they find a repression, they put in a regime of repression to just get you out because they think that since we came, you remember the call they made, since we came from independence, Sammy James was one of those guys that said it. Every chief justice or some of these senior positions have always been appointed or occupied by people who were appointed by the MPP. Was the Justice Aban appointed by the MPP? You lost cases under Adam. Was Justice the distinguished jurist Acha appointed by the MPP? You got judgments in your favor under MPP. Under Justice Acha. So if you suffer judgment under Redu, Aqua, Georgina Wood, or any Yabua, Sophia, or Tokonu, the thing they accuse her, didn't the Sedu come to tell us that? You may hear chairman, you may hear no crowd before Sumasi. In the end, when the matter went to court,
if this was said by an MPP person, you would have said it was a campaign.
It was on
a campaign platform. How can you use a campaign?
Did your chairman deny?
But is that not a distinction between political statement? You have been using Wontumi's statement against him.
Wontumi's statement,
and then somebody's using somebody's
Wontumi's statement was not on a political. Was not at a political
but
campaign.
It was political talk.
No, but it was not at a political rally or campaign.
So it's only a political talk if it's at a rally.
Yes, that is what it is.
Oh, okay. All right.
No, not a rally, at a campaign.
Did your chairman
campaign people and he was telling them what he can do
because of time. Because of time.
So my brother, yes. Concluding.
Yes.
They can't kill her like they did to Justice Cecilia Krantinado. Japan's father was Justice of Japan. And the 2 other justices of the High Court, they can't kill them.
Do you know that the military officer, Major Aqua,
yes,
who was killed,
he was a chairman. He was I think Manny Dr. Gihok.
Yes, but do you know that the current Chief Justice is his uncle?
So
direct uncle.
So you see,
yes. In fact, the Chief Justice, we are told, was living with Major Aqua.
So you see,
at the time he was adopted and killed.
So you see,
so there's a direct relationship.
So I'm not doing the wrong scenario. The permutation is excellent.
Okay,
they can't kill her. As Israel of the murderers, they get away with murder, and today they say we let get the woman out of it.
Okay.
So you remind us of the pain. Do you know that Krantinado was nursing the baby when he was murdered?
Yes.
He was taken from her home to Bundasi, hacked into pieces.
So let me just disclose that the day Krantinado was adopted in her home, and you know the home where she used to live. The home is a house behind President Akufo-Addo's house at Nima. So the day she was adopted from the house, my own mother had given birth to me fresh, and my mother was in the house when she was adopted. Okay, so that's just a little bit.
So you see the pain. So you see the scenario.
Okay,
and you see how history has repeated itself. A tradition born with the blood of the people of Ghana, and has, even when it has transformed itself from a PNDC to an NDC, a congress of political party of the, as they see it, the blood instinct of eating up people and messing their life has never ceased. And that's the vow of His Excellency former president.
Okay, so we actually ran out of time, but I'll come to you, Dennis, quickly. The Supreme Court's ruling implies that because a process is constitutionally created, it is somehow immune from constitutional scrutiny, even when it violates the basic rights the Constitution itself proclaims to be invaluable.
You understand
you understand the argument?
You understand it?
Yes, I do understand. And I want to find out from Dennis. Dennis, as you make your comments, this Abdul Basit Mahama is saying that there is a constitutional provision, and then we are trying to respect the constitutional provision, but we are respecting it in violation of another provision in the same constitution.
Well, I do not see that.
Okay.
I do not see that.
Unfortunately, you have only 2 minutes.
Look at that.
Unfortunately, I'm sorry.
You see, Wilberforce, I heard counsel saying that, what sort of Supreme Court do we have? And I was like, interesting. You see, this is a matter of the manager of the system. She is, though suspended, are still the head of the judiciary. So if you see any rocks, if you think that the judiciary is sick, she should be the right person to answer to the sickness. This issue about the NDC saying that when they come, the Chief Justice will do this or do that. The petitioners, to the best of my knowledge, none of them is even a card-bearing member of the NDC. And the president, as it stands today, has not violated any provisions under 146. He's just going strictly according to the dictates of Article 146. As to whatever applications the Chief Justice suspended has filed and whatever has been done to it, it's a matter of how she has kept it. She has kept the Supreme Court, how she has managed it, and how she has lived with her own people. Look, I can tell you that if you have an issue in this office, and your producer is asked to chair a committee to investigate you, you'll be confident that you will come out without any bruise or any scar. But if you are not living properly with your producer and other staff, and there's an issue, and your own colleagues are supposed to preside over a committee to investigate you, and you are over the rooftop crying, you should ask yourself, what relationship have I built with my people? These are basic issues. For me, if I am asked to be investigated by my colleagues, be them from the NDC communication, from my office, from my firm, I think that within myself, I've built a good relationship with them. And so I will always believe that I'll have a fair outcome, to the point that if I'm judged to be wrong, I will say that yes, I accept I'm wrong. If not. But what is going on should tell you that there are some cobwebs,
undercurrents
that her leadership is scared of.
So the matter has been concluded.
There are some. No,
but have you heard about the phrase "green eye monster"?
No, I have not. I've not.
He has run away from the issue.
So I'm saying that I have not. I don't know what a monster. I don't even know what a monster is.
A green-eyed monster.
I say I don't even know what a monster is.
Okay, have you heard of the word envy before? Envy.
Yes, I know about envy.
You know about envy?
Yeah, I know about envy.
So when we talk about envy is referred to as a green-eye monster.
Okay. Yeah. And so why would someone envy who? And you see, in this case, there are about two persons from home on the committee.
One of them
would the two
petition against
wait. Would the two all have what your description says?
Okay, so unfortunately we've run out of time, and I couldn't even go back to my friend. Okay, Oxford, just 30 seconds to wrap up the show. Oxford.
Yes. So first of all, I think we have to do a balancing act. See, what the Supreme Court is doing is actually upholding the provisions of the Constitution. First of all, we actually don't have any format or any modality of establishing the prima facie case and then the subsequent procedure that comes with it. So it was interesting to hear from you that they did it by voting. If they did it by voting, it means that they put all the three petitions together and decided that we have voted to see that there are merit or that there are some relevant things that within the petition that we have to look into the matter. So it is by way of saying that, no, there's a need for us to look into this and then see how we can come out with a fair conclusion. So, well, let's see, like I mentioned it earlier, in that case, I mean, what are we, evoking the powers of the Supreme Court against? Because we don't even have a laid down procedure or regulation or say specifically stating how to even establish the prima facie case. So all what we say is that, we have to pray for the Chief Justice and believe that he will gain the strength to go through this procedure and then come out clean with no, blemish. So that is what I think will be the case.
Indeed. Thank you. Thank you very much, Oxford, for joining us via video link this morning. I really thank you for doing the same. All right. So we are ending the show this way. And Abdul Basit Mahama has a message. He says that the posture of the Supreme Court panel in the CJ's matter is akin to saying that the Constitution can lawfully wound itself, that it can arm one provision to attack another without consequences. Okay, so interesting message there from Abdul Basit Muhammad. There are some other messages. Unfortunately, I'm unable to read all of it. So good morning. I can assure you that what the NDC is doing today with the arrest of the former appointees of the SY MPP administration, the MPP will do far better than them when the tables are turned, so they should be aware of it. And that is Musa Baba. Okay, so there is Kingsley who sends me a private message and says that he thinks that Mr. Jemfi has brought a lot of historical relevance to flavor today's discussion. Thank you very much, Mr. Alex Jemfi, for your historical relevance to flavor the conversation today, and then also for coming. All right, so that has been the show. Several messages. I'm unable to read all the rest. The acting CJ and the Mahama administration will have learned something from the ruling of Mad Harriet. Okay, it is easier removing the CJ. Oh, so you are talking about Madam Harriet Mensah Bonsu. It is easier to remove the CJ than a class prefect. And that is the message that was sent by Samuel Ofosuba to end today's program. The program has been produced by Daniel Gidiglo and Emmanuel Ohime. My guest who joined me today, lawyer Dennis Ofori Esiedu. He's a member of the National Democratic Congress and a lawyer in private practice. Lawyer Alex Jemfi. Lawyer Alex Jemfi is a lawyer also in private practice with a lot of institutional memory. Yes, and he doesn't mind being called a member of the MPP.
Why do you it's mine and leave it?
And then Oxford Osei Bonsu is also a lawyer in private practice. He joined us via video link. Earlier on, we spoke to Kwame Adofo. He's also a lawyer in private practice. Today's show was all about lawyers. My name is Wilberforce Asaase. Thank you very much for the privilege of your company.
Thank you for watching. Like, comment, share, and subscribe.